Thank you. Good morning, everybody. It's a real pleasure to welcome all of you to the 10th Bowman's Africa Competition Law Conference. This should have been our 12th conference, but somewhat of an inconvenience arose between then and now. In particular, I'd like to welcome and thank everyone who has traveled to be here, and also everyone joining online. I know there's a large number of people that have joined online, so we really appreciate that very much. And I must say, the last time I saw some of you was this time 2 years ago here. And in fact, the judge was giving the address at that time as well. So it's a great pleasure to see you all, and we look forward to today. My co-head, Tamara Dini, and the competition partners made a decision quite late to go ahead with the hybrid conference. And we must thank everyone for making the effort to be here and for the arrangements that were made. Your presence, I emphasize, is greatly appreciated and adds significantly to the event. So sincere thank you. I must really thank Tamara, the co-head of the practice, who put this all together and for all she has done. This conference is a key reflection of the strategy of our firm. Currently, we have offices in 6 African countries: Kenya, Mauritius, South Africa, Tanzania, Uganda, and Zambia. We work closely with our Bowman's Alliance firms in Ethiopia, Aman Assefa and Associates, and in Nigeria, Udu Odoma Obelo Osachi. These are 2 of the leading corporate and commercial law firms in those jurisdictions. We have special relationships with practitioners in Malawi and Mozambique, and we also have a non-exclusive cooperation agreement with the French law firm Gide, that provides our clients with assistance in Francophone, West and North Africa. Bowman's has the objective of offering on-the-ground strategic advice to clients that balances commercial requirements with legal and policy realities and imperatives. When we last met prior to the pandemic, I mentioned that the competition law landscape has changed dramatically, and this flux continues to be the case. I mentioned that tests for competition law outcomes that were accepted as gospel just a short time ago have been turned on their heads. And the focus is now on preserving structural competition, with regulators becoming more interventionist. This has been most evident internationally, where regulators have focused on the digital space and on information and data and the market, economic and societal power that creates, even where there's no immediately apparent or obvious harm to consumer welfare. In South Africa, the Commission has been very active and taken steps to protect against abuse and exploitation during the pandemic. And this has been facilitated to a degree by exemptions issued by the Minister directly related to the pandemic. While the Commission has been somewhat blunt, if you don't mind me saying that, in its approach at times, and wanting to convene a press conference at the drop of a hat, the Commission should, on balance, be commended for its steps during the pandemic to date, as should the tribunal, such as with respect to excessive pricing on essential goods. The Commission in South Africa has also grappled with the public interest provisions of the Act, especially insofar as questions relate to ownership in the economy, localization, employment, and other factors are concerned. And the Commission has attracted, I would think, some legitimate criticism for not providing proactive guidance on the approach to the meaning and application of the new and far-reaching provisions of the Act are concerned. And the Commission's approach in the Burger King matter, while I must emphasize justified as an effort to address key imperatives in South Africa, did South Africa no favors as an investment destination. And the decision caused much business uncertainty, and the Commission is well positioned to mitigate that uncertainty by offering proactive guidance. And I emphasize, we were not involved in the Burger King case. We saw it from the outside like everybody else did. Competition law is being used as a key tool to address economic policy outcomes or factors in jurisdictions, and significant levels of business uncertainty are being occasioned. The perceptions around regulation by delay or by blanket internal policies does not create an investor or business friendly environment. And the Commission should be encouraged to foster its role as a key gateway to investment in South Africa. I read with interest the comparative comments of EU Competition Commission Vestager that she is not ready to adopt the view that wider policy issues fall to be considered in competition assessments, and that competition policy risks becoming inefficient in achieving core goals if it focuses too much on broader debates. She said that legislatures should set the rules around issues and then tell companies to go and compete within that framework. And I appreciate the circumstances in Europe are different around environmental issues and other issues, but I still think that is a point worth considering even in South Africa. I think that competition policy in South Africa should consider this perspective and avoid overly using mergers to address policy outcomes. Put differently, mergers are ad hoc events, often with beneficial outcomes, and policy intervention specific to a merger that does not apply to any other participant in the sector may not always be appropriate. Policy objectives are better achieved by legislation of true general application. Furthermore, I trust you don't mind me being somewhat more direct again. The Commission should also be encouraged not to formulate cases as per se, especially horizontal prohibited practices, where they may more correctly be assessed under the vertical or effects considerations of the Act. This they seem to be doing to lessen their burden and their onus in cases. And the recent Westbank Toyota case comes to mind. We're not involved in that case either, but looking from the outside, that looks like a case more appropriately assessed under the vertical effects provisions of the Act and not as a per se contravention. Moving on, some other developments across our continent. I want to mention that the African Free Trade Area Agreement has been implemented. That refers to the Protocol on Competition, which aims to provide a continental approach to competition. Angola has joined the list of countries having an active and an independent regulator. COMESA continues to be very active and for the first time issued a penalty against firms for late notification of a merger. The CCC also fined companies for breach of a merger condition, launched an investigation into beer producers operating in the common market, and the COMESA has indicated that it intends to implement a corporate leniency policy. ECOWAS has signaled its shift towards greater competition law enforcement. Egypt has sought to prosecute firms for failing to notify mergers and to criminally prosecute firms for engaging in anti-competitive practices. The Eswatini bill is expected to replace the current legislation in its entirety. Over the past year, the Kenyan Competition Authority has been very active and strengthened its enforcement powers. It has published a host of regulations and guidelines, and I think we now know where South Africa gets its ideas from, or it may be the other way around, I'm not sure. In Malawi, the Commission has signaled its intentions to strengthen its enforcement, and the Mauritian Competition Authority has prosecuted anti-competitive practices, ordered its first divestiture in a merger, and launched a number of investigations. The Mozambican Competition Authority has now become fully active, and merger notifications are being presented there regularly. And the CRA has now indicated it's going to move to addressing anti-competitive practices. During the last year, and following extensive lobbying practices, the Federal Competition and Consumer Commission, FCCPC in Nigeria, adjusted its merger filing fees, thank goodness. In relation to anti-competitive practices, the FCCPC conducted dawn raids on offices of various shipping companies and also indicated and initiated investigations in a number of sectors. 2001 has been another very busy year for the Competition Commission. Notable highlights include the launch of a market inquiry into online intermediation platforms, a revised draft small merger guidelines intended to capture small mergers in the digital space that do not exceed the thresholds. A competition policy for jobs and industrial development has been issued. Draft guidelines on collaboration between competitors on localization initiatives have been issued, and there are proposed changes to the merger filing forms. The Zambian Competition Authority has launched a number of investigations, one of which the main one into independent beer distributors for alleged tying and bundling and facilitating unreasonable price hikes in the market for clear beer products, and also ordered firms in the cement industry to lower their pricing. The Zimbabwean Competition and Trade Commission fined parties for prior implementation of a merger and launched a number of investigations. It's with that context in mind that I hope that you will enjoy the panel discussions today. But it's even more of a pleasure for me to welcome again Judge Dennis Davis to give the keynote address. Judge Davis is a retired judge of the High Court and Judge President of the Competition Appeal Court. He continues to teach constitutional law, tax law, and other areas of law at UCT, where he's an honorary professor of law. He has been a visiting lecturer professor at the universities of Cambridge, Florida, Toronto, and Harvard. Judge Davis was a member of the Commission of Inquiry into the tax structure in South Africa and was an advisor to the Constitutional Assembly for South Africa's interim and final constitutions formulated as constitutions that were formulated and concluded. Judge Davis has been asked to consider some of the most tricky competition issues in South Africa since the promulgation of the Competition Act. And it's with that it's a real pleasure to welcome you again, Judge.
It's a sheer delight to actually address a live audience for the first time in 2 years and be back at Bowman's in that time. And you know, I was just thinking about it in terms of what Derek said. So much has happened in the last 2 years in relation to competition law as a whole that it's kind of difficult to try to reverse all of this in the context of one speech. You'll forgive me, perhaps indulge me, just 1 second before I begin. I can't help but not note this. Of course, when I was last here to speak at the Bowman's conference, your chairperson was Robert Lee. And Robert was a friend of mine and somebody that I had the highest regard for. And it sort of weighs on me today, if I may say so. And can I just say one thing about Robert, which, in honor of him, which is not entirely irrelevant to what I want to talk about generally. Throughout my period as Judge President of the Competition Appeal Court, which for some seemed to be interminable, and for me was, because it was over 20 years, one of the things that I noticed quite early on and gave me greater and greater anxiety as the years rolled on was the issue of briefing practices. And whilst bearing in mind my own categorization of demography, I'm hardly against white men, it did seem to me that there were other groups in our society, to put it mildly, and it was really a great deal of anxiety to me that continuously we hardly ever saw any black counsel, any women counsel. And over the years, because I've taught competition law since its inception in 98, and indeed even before then, I obviously know that many young women and black lawyers, black women lawyers as well, had passed through our ranks and the ranks of other law schools, and that some of them had gravitated to the bar. And quite frankly, unlike a number of the white men who appeared in front of me, I stress not all, and maybe not even a majority, but these people did know the difference between a supply curve and a demand curve. And actually did know that competition law was a specialist issue and that you didn't simply move seamlessly from a road accident fund case to a competition law case the next day. In other words, it's kind of a bit difficult, is it not, to actually have to deal with question of, say, as to whether in fact the motorist was negligent to dealing with the question of predatory pricing. They have slightly different demands. And so I call the firms, the partners of the firms who do competition law, not once, twice, over a period of time. And on the second occasion, which is why I wanted to mention this, on the second occasion, they all arrived, and Paul Kutzer, who was then running the competition sidebar, whatever it was called, committee, kindly organized a meeting at Worksons where he was partner. And of course, bearing in mind that one is the judge president, it's hardly likely that these particular partners were going to turn around and tell me to go away. So they all came. And we had a long conversation about briefing patterns. There were some really bizarre remarks made by some people. One particular prominent competition lawyer told me when I suggested that we should be more diverse in our briefing patterns, because at the end of the day, my concern, apart from representativity, was that over the long haul, I wanted to make sure that we had a number of competition judges drawn who were demographically representative of the whole country. And how was it ever going to happen if we were perpetuating the same kind of patriarchal white system of the past? And one of them sort of said to me, but Judge President, we don't know all these traps. To which I said, actually, I'm not only talking about traps, I'm also talking about women, which really kind of, you can just imagine the climate. And so they were all umming and ahhing. And Robert Lee, who was there, and I think was chairman of Bowman's at the time, and therefore brought a sort of both moral and legal stature and physical stature to the entire proceedings, had said nothing. And then he said to me, Judge, you're absolutely right. And we've had a conversation about this at Bowman's because we're also worried about this. And let me give you this undertaking that in our firm going forward, unless clients absolutely object to the composition of the team, we will have a woman or black lawyer in our litigation team which argues these cases going forward. And that was a remarkable intervention because all the others then fell into line. And I desperately admired Robert both for his principle and for his understanding of exactly what is required if South Africa is to become a non-racial, non-sexist democracy. And it's in memory of him, therefore, that I deliver this particular talk to you today. Now, the problem that I face is that competition law, and Derek has made the point, and he's right to make the point, competition law, if it was an inflection point in 2019, is certainly at an even greater inflection point in 2022. When I started teaching competition law, and I was particularly influenced in this regard by Professor Eleanor Fox, one would really talk about two, perhaps three models of competition law that existed. The first one, the obvious one, particularly since we were coming out of the 1990s, was the Chicago School. And effectively, the concern was essentially with prices and output. And that essentially was conflated with the definition of consumer welfare. The European model, which at that particular point in time was being pushed by Mario Monti, another of the remarkable European commissioners who have been in office, was very much about what I suppose one would call the competitive process. The idea being that what competition law was about was to ensure and facilitate a competitive process in which entry and exit were equally possible, and that therefore you did not have a kind of agglomeration of power which was concentrated in perpetuity and therefore reinforced an economic status quo. And the process model, of course, was what demarcated, if you could put it this way, the debates that were taking place across the Atlantic between the American competition situation and that in Europe. And then there was a third model, very nascent at the time, not particularly well announced, but there it was, which you could call, if you wish, as I used to say to my students, competition process plus. And it was there that they were starting to nibble at the edges, issues beyond just competitive process. The kind of things that today we broadly put under the rubric of public interest. And that particular third model, which essentially was encapsulated in express terms by the public interest concerns under mergers in the South African Act of 1998, at that point in time, was very much an outlier. And I remember particularly addressing the plenary session of the OECD, and Frederic Genie had asked me to come to talk to these plenary session about public interest questions in competition law. And I remember going to this massive hall with delegations from all over the world. And with one or two exceptions, they thought I was completely nuts when I was actually talking about the public interest concerns that effectively were contained within the South African legislation. Roll on 22 years, and that's the debate now. And we can't get out of that debate. The debate is, what is the appropriate normative framework for competition law in general, but in our case, for developing countries in particular? And that's the really fundamental question. Let me make this point, which I don't have time to develop. I want to argue that we've never really developed that in South Africa. partly my fault, perhaps, having authored so many judgments. Why we haven't done it? Well, we can talk about that if you wish. But the point matter is that, broadly speaking, that hasn't occurred. And it's fascinating to me that right across the world now, there are now conversations about whether that third model, nascent as it was in the 1990s, is now one where we have to consider it to a far greater extent than previously was the case. And in preparation for this particular talk, I went to reread a whole bunch of stuff which I'd taught and read before, but I just wanted to have another look at it. And I'm particularly referring here, amongst other things, to an article. She's written many things, and I have read most of them, but just a short article, which was written about a year and a half ago by Lena Khan, who now, of course, has gravitated to a rather more powerful position than me, being a student at Yale University when she wrote a famous article. And of course, Lena Khan is equated to a large degree with the Brandeis school of competition law. But it is interesting to me, and this is a segue into what I want to talk about in relation to these broad questions. It's interesting to me what she says and what she doesn't say. What do I mean by that? She starts off by talking about the fact that anti-monopoly law, and she's really conflating that, if you wish, with competition law, is a key tool, she says, and philosophical underpinning for structuring society on a democratic foundation. Recalling the words of Louis Brandeis in 2012, she says, when he asked, what does democracy involve? Not merely political and religious liberty, but industrial liberty also. The Madisonian concept of self-government hinges on the ability of citizens to control and check private concentrations of economic power. Surrendering this ability, Brandeis noted, would mean that there is a power in this country of a few men so great as to be supreme over the law. And the first proposition, therefore, that the Brandeis and now the neo-Brandeis school are arguing is that the structure of the economy is inextricably linked to the democracy of the country. I hardly need to tell a South African audience how true that is. Question isn't the truth. The question is, how far does competition law play in dealing with this particular problem? And there lies the rub. Because even Lena Khan, in the development of her article, says, when we deal with anti-monopoly questions, this is far more than antitrust. In other words, the second proposition she advances, and rightly so, recalling, if you wish, both the dicta in the Competition Tribunal and the Competition Appeal Court in the Walmart case, which I suppose you could really say started all the trouble, is that competition law cannot change the world. That competition law is one tool in a broad toolbox of dealing with questions of structural concentration and the conflation, as it were, of economic and political democracy. And so her caution is that even in the United States of America, there were at its best a whole range of institutions which were designed to deal with this broader question, of which the competition authorities were merely one. And she then goes on to say that, of course, anti-monopoly does not mean that big is bad. And that's not an unimportant consideration either. You can't just simply conflate the one with the other. One's got to be very careful about how one interrogates that, she argues. Finally, and not insignificantly, she says the following. The Chicago School focused on consumer welfare as such. And this has warped America's anti-monopoly regime by leading both enforcers and courts to focus mainly on promoting efficiency, on the theory that this will result in low prices for consumers. The fixation on efficiency, in turn, has largely blinded enforcers to many of the harms caused by undue market power, including on workers, suppliers, innovation, independent entrepreneurs, all harms that Congress intended for the antitrust laws to prevent. The resulting system is so warped that enforcement efforts geared around consumer welfare have, according to important recent studies, resulted in higher prices and markups, meaning this philosophy fails even by its own standards. And then she continues, contrary to how critics portray the neo-Brandism, this school of thought does not promote using antitrust law to achieve a different set of social objectives, such as more jobs or less inequality. Doing so would replicate a key mistake of the Chicago school, overriding a structural inquiry about process and power with one that focuses on a narrow set of outcomes. I want to emphasize that. Yeah? She says, you don't want to make the same mistake as Chicago did by overriding a structural inquiry about process and power with one that focuses on a narrow set of outcomes. Refocusing antitrust and structures in a broad set of measures to assess market power can return the law to focusing on the competitive process. Now, it's that context with which I want to address, in the time available to me, some of the concerns about how far competition law should extend within the African continent in general. But the truth about it is there are a whole lot of people in this room who know more about other parts of Africa than I do, including my ex-student, one of my best PhD students I ever had, Dr. Willard Mwebi from the Zambian Competition Authority, of whom I said last night, why doesn't he come and take over the South African Competition Authority? It wouldn't be a bad idea. But what I want to talk about is in general terms. So what she's saying is this: let's leave aside questions of freedom, democracy, etc. She's saying those are broad issues, but they're not necessarily competition questions. They are the broader overarching issues that we have to deal with. And by the way, en passant, if I may mention, that in relation to questions of structure and power, part of the design of the Constitution was effectively to render both public and private power accountable. That's why the whole debate about horizontality in the Constitution was such a fraught and interesting debate all those years ago. And of course, we know that the Constitutional Court has hardly embraced the real challenges thereof. But if you are even remotely cognizant of the school of critical realism, started in the United States of America, but taken other places, you will know that all sorts of law, contract law, property law, dealing, all have massive effects on structural concerns in an economy reproducing a particular economic status quo. And I mention this only for one reason, that to use competition law as your main source to address this is a fatal mistake and overreaches in extreme circumstances, having polycentric consequences, use the fuller term, which competition authorities cannot predict. That's the take-home point. Now, how then did public interest develop? Well, everybody quotes the Walmart case. So maybe it's not a bad idea in a conference struggling to look at public interest and balancing all these competing objectives to just for 2 minutes traverse what in essence that particular case was all about. And there are a few take-home points there too. You will recall, of course, that the problem with Walmart in the first place was that there were no, as it were, cognizable competition questions. No one was suggesting that output would be depressed if Walmart took 51% of Massmart. Secondly, no one was suggesting that prices would go up. Walmart brags all about the lowest prices. And I remember having a long debate with counsel in court saying, take a simple proposition of poor people having, because of our school uniform policy, that they have to buy a white shirt for their child. Now, if they could buy the white shirt for 10 at Walmart, but the rest of the places were charging it at 12, the fact that they could now get it at 10 was, of course, an extraordinary advantage to poor consumers. So those issues were never really in play. What was in play was the fact that when you looked at the overarching structure, to what extent did you have to give weight to public interest considerations? And if you read the judgment and the evidence carefully, then a couple of consequences emerge. In the first place, the two concerns, that is standard SLC on the one hand and public interest on the other, are inextricably linked. Contrary to what is happening today, and I'll get there, public interest isn't some free-floating idea. It's not an invitation to rent seeking, either by the minister or the commission. It's supposed to be part of an integrative inquiry. In fact, one of the big issues in the Walmart, and ironically, one that was pushed by the now chief economist to the Competition Commission, James Hodge, who was then the union economist, right, was to argue, could you balance the, let's say, advantages to consumer welfare by the concerns I've spoken about? That's the price decrease or the output increase, to the potential evisceration of small and medium-sized enterprises, because Walmart would have a global value chain, which would ultimately work to the prejudice of small South African producers. And James Hodge heroically tried to do precisely that. We read a significant amount of evidence about seeking to balance these two issues, because he knew well then, and he was right, that this was an integrative approach, that you had to deal with both. That is, even though you dealt with this SLC, you still had to then deal with the public interest in the broader inquiry. And that was absolutely central to the Walmart case. There was another issue about the Walmart case, which I should also add, was the extent to which, leave aside the public interest, what content were you going to give to substantially lessening or preventing of competition? Were you going to simply attribute to it the barometer of price and output? Were you going to deal with the question of the competitive process? Or were you going to actually look at the very normative framework of competition law to build into the initial inquiry a whole range of concerns which you could call social and political concerns in the broadest sense of that word? Now, we cautiously did not deal with that, partly because when you're a judge, you've got enough problems on your hands and you just try to deal with the case in terms of getting the best result you can without, contrary to what academics think, having to pontificate about a whole range of issues which are utterly irrelevant to the disposition of the case. But it always worried me. And when I went back to have a look at what I'd written in Walmart, there were quite a number of passages dealing with this particular question of what, in fact, consumer welfare meant. And a great deal of reference to some really thoughtful writing at the time by a German competition economist, Wolfgang Kerber, whose work, by the way, if you get it, is always worth reading. But I'll leave that aside. Walmart did not argue that public interest was some self-standing concept which absolutely had to be taken separately from the broader inquiry. The two had to be looked at together. And after all, if you look at the Act, that's clear. What you look at, you may prohibit a merger for public interest grounds. You may attach a whole series of conditions thereto, but you're doing so in terms of an overall inquiry. And what has happened, it seems to me, within the South African context, is a couple of things. Number one, we've added to our act in a whole range of issues. And of course, there are some African countries who've included public interest concerns in the abuse of dominance issues. And let me say this about that. That is certainly where the issue of what, in fact, the purpose of competition law is. That's where it comes home. Because abuse of dominance certainly needs to look at the structural questions to which Lena Khan referred. And there's a battery of literature which would support that particular proposition. But it's not easy. And it can't just be done in a sloppy and non-integrative way. But to return for the moment to the question of public interest, it's obvious to me that what has happened within the public interest domain in South Africa is there's no integrative approach at all. There seems to be a sort of bargaining in which somebody wishes to do a merger, and then to a large degree what happens is that, well, let's deal with public interest. Let's extract some conditions. Why? Because that's what the Act says. How? Well, don't worry about the broader issues. And think about how absurd that is. Because when you look even at questions of employment, you've got to ask yourself, are you looking at it through a short-term lens or a long-term lens? What's the effect of the merger long-term? We're supposed to do that anyway, aren't we? Because when we look at questions of merger control, we're generally interested in that because we're worried about what the merger might do in respect of unilateral coordinated effects. We're interested in what this will have on the structure of the market as it exists, and you're peering backwards and forwards for that purpose. But you sure as goodness, in this particular instance, looking at the merger as a whole and what the effects would be. And therefore, one's got to be very careful by just simply tacking on a series of short-term concerns and arguing, one, that's congruent with the Act, and two, that gets you a more transformative competition vision. Because if you look, and I did a search of recent public interest conditions imposed by the South African Competition Tribunal, I have a whole list. I'm not going to bore you with them all, right? But let me just give you some. I won't mention the names of the companies, but I'm happy to do so if you want me to, right? There's one which says, well, there's one, ShopRite. They must endeavor, in line with its proposed expansion plans for the trademarks, to open outlets operated by a franchisee and a trademark's name over the next 5 years, subject to economic conditions. Well, I'd like to know to what extent that, for example, I can assure you what wasn't done there was any integrative analysis as to what the effect of the merger is going to be. And then you get the next one. Commission, the merging parties agree to a condition that the merged entity will continue to supply third-party customers of the one company on market-related items. Another one, provide financial and other support to an HDP-owned gas transport company entering the market for specific specialty gases, and provide technical advice and support to an HD-owned potential provider of carbon dioxide related to the establishment of a carbon dioxide panel. The acquiring group, another one, has committed to entering into a triple BEE transaction with the triple BE investment partner. The triple BE transaction results in investment partner having a specified percentage shareholding. That comes up over and over and over again. Now ask myself, I know that part of the Competition Act talks about the spread of ownership, and particularly to historically disadvantaged persons. And I think that's true. It's something, as part of the drafting team, I'm proud that we had. But what was the purpose of that? Was it simply to say, oh, well, we allow the merger, but you give 25% of the shares to XYZ? Or was it to actually say, a la Walmart, we're really concerned that if this merger goes ahead, there will be significant effects on small and medium-sized businesses, in particularly those owned by historically disadvantaged persons. Because it seems to me, you go through this list I have over and over again, the question of attaching, Commission found that there would be a dilution of ownership by historically disadvantaged persons at the company. To address this concern, parties agreed to conditions to maintain a certain level. I am totally in favor of the transformation of the economy. We don't have that, as I think Brandeis makes the point, you won't have political democracy in South Africa. That's obvious. The question is this the role of competition law? And more important, is this the role of the merger inquiry, without a comprehensive analysis into all the factors which then give you a basis by which to deal with the public interest concerns. Recall that in the Walmart case, which of course is cited over and over again, the reason we came up with these conditions was because after an analysis of the entire merger, we had concluded that there was a real possibility that because Walmart would essentially look to its global value chain for various inputs into its business, and because it could get it cheaper in other parts of the world, then all of these other large retailers, such as Pick and Pay and ShopRite, Checkers and Woolworths and Spar, would follow suit to the detriment of small business in South Africa, to the detriment of the growth of small business in South Africa, and ultimately, and obviously, to the detriment of the transformation of this economy, which is absolutely imperative to ensure that it represents broadly the demography of South Africa. But that emerged out of a serious inquiry. This wasn't some sort of bargaining chip that you say, okay, we'll do this if you give me A. That's not what competition law is about. And when I go back to Lena Khan's point, if you're going to worry about short-term outcomes, absent the broader structural concerns, you don't transform the economy. You just rearrange the deck chairs on the Titanic. And that's why I say that we have to a large extent, and I'm running out of time and I had another half an hour to go, but don't worry, I know we've got to finish before 9 and I will, I promise. Terrible to have judges having to constrain their time. Much we do it the other way around. We tell counsel you've only got another 5 minutes, which, by the way, generally doesn't really help. The point I'm simply making is that what worries me is we do not have a serious guideline as to what we're doing, either in relation to mergers or in relation to abuse, to which I've just had peripheral reference. So let me make one final point about abuse, and then I want just for 5 minutes to end by just talking about the implications of Mediclinic, which is not an unimportant consideration looming large here. What I wanted to say about abuse is that when the amendments to the Act came in, Minister wanted them. A number of us said to the Minister, how far do we go here? Because what we should be interested in doing is ensuring the most vigorous implementation of a process model to ensure that all forms of obstacles created by the structure of the South African economy, as it were, be loosened, so that in fact, instead of perpetuating a status quo, which has got us into terrible trouble at the moment, V-Day our growth rates, which nobody in this world actually thinks going to go above 2%. I challenge you all to tell me that the Minister of Finance in the budget next week will say anything more than that. And I'm probably being optimistic at 2%. And I say this in sadness, not with any glee. But the point I'm simply making is that to actually think through how we actually use competition law in the abuse sections to loosen up, as it were, the constraints on the economy and prevent people from entering it and prevent them from participating properly. That's the challenge. And what worries me is I don't think we even got there with the pre-2019 amendments. So the question is, it's not a question of amending, it's a question of actually thinking through what is the normative framework which is going to inform the inquiry in the first place, which of course circles back to my earlier point of public interest. Now, I could, and I think if we don't have a debate about this in serious ways, and that's why some of the other African countries which have used, I noticed Botswana, which has some rather kind of clear guidelines in relation to abuse in public interest. Well, that's interesting. I'm not sure you need those if you actually can interpret the concepts of competition law in a manner as I've tried to indicate. The Austro-Marxist economist Karl Renner, almost a century ago, said that the real issue in changes of law is you don't change the concepts, you change the content. And what he meant by that was that it's hard to dream up different concepts of law. It's the question of what content you put into those concepts of law, which is what I'm really making a plea for. So let me end, because it's on the same theme, with the Mediclinic decision. Well, two things or three things. First, I invite you to read the judgment of Judge Rogers compared to the majority judgment in the Constitutional Court. If you read Judge Rogers' judgment, in typical Judge Rogers style, because he's an extraordinarily meticulous and thoughtful judge, you have a serious analysis of the market, of what the geographic and product markets are. You then have a conclusion that once you've got to that point, what pressures of a price or quality of medical service are there? And he does, in this regard, look at Section 27 of the Constitution to say, does that in any way tilt the balance? It's an evidentially based judgment saying at the end of the day, there are not SLC questions. And he does that on the basis of evidence. If you look at the majority judgment, because there is a minority judgment too in the Constitutional Court, there's some absolutely extraordinary propositions. There's this question of, well, why was Judge Rogers worried about market power? The judgment is obsessed by market power, accuses the majority of the Constitutional Court. There's no, there might be a price increase here and there, therefore there's an LLC question. Well, we all know, if you know anything about competition law, particularly when I admitted to the earlier questions of unilateral and coordinated effects, what we worried about in mergers is, in fact, whether there'll be a change in the power structures of the market. That's the whole point. And for the highest court in the land to eschew any such consideration and use it against the judgment, well, that just puts our merger law into a catastrophic sphere of uncertainty. But it goes further. Because, and here is the one point that I support the judgment completely, it does emphasize the importance of the Constitution in Section 27. Let me say this, that when many years earlier, we were confronted with the possibility of the Treatment Action Campaign bringing a competition challenge to antiretroviral drugs, I couldn't wait for that. Great sadness that it never got to us, because it seemed to me that there was a case where you did your competition analysis, but if there was a debate about the interpretation, a debate about the implications, you had to take the right to healthcare into account in a very careful way, as indicated under Section 39(2) of the Constitution. So I'm all in favor of that. But that's not what now has happened. What has happened is, it seems to me that Section 27 now is used as a trump card. You don't have to worry about any of the evidence. Oh, Section 27 applies. Bingo. We have now arrived at the jurisprudence of that wonderful Australian film called The Castle, where effectively, you may recall, those of you who know, when some counsel who's helping this man try to protect his property and knows nothing about constitutional law is asked by the court, well, what section of the Constitution do you rely on in order to say the property should be expropriated? And he turns around and says, it's the vibe. And we've now reached the vibe. And so now what happens, from my information, is that in every case, the Competition Commission seizes on the constitutional question, absent a rigorous competition analysis, of which Section 27 must be a part. And so the only point I want to make, since I'm out of time, is that this, therefore, brings me back to the beginning of my talk, which is, I'm totally in favor of a reconsideration of competition objectives way beyond the question of the Chicago School. I agree with Lena Khan that there's structural questions that we have to address, which is where the inquiry should be informed. But that requires an analysis of the economic evidence. It requires an understanding of what is the objective of competition law, It requires a situation that competition law does not, as it were, should not be used as the tool, to quote Khan, to address inequality and jobs as such. Of course, by virtue of, in fact, having a progressive competition law, inequality will, in fact, be redressed in the long run, because the fact of the matter is you'll change the structure of the economy. But that requires hard yards. It doesn't require the vibe, and it certainly doesn't require the idea of simply looking at a first port of call at the public interest considerations, absent a rigorous understanding of the entire process of a merger, or alternatively of the practice of the dominant firm, to indicate that in fact those public interest concerns are triggered and in fact override what might be more tangible, traditional, cognizable competition considerations. That for me is a massive challenge ahead of us. But if we do not solve this one, our law will continue, as it were, to descend into a morass of uncertainty, which is not just going to be disadvantageous for investment, and Derek, you're right on that, it also is going to be disadvantageous for the broader nature of the South African economy, which has to work, must work, and we have to get it to work for 60 million South Africans, most of whom today are not just historically disadvantaged, they're presently disadvantaged. And that is a disgrace after 27 years of democracy. Thank you.
Session we just had with Judge Dennis Davis is that we have been schooled. Yeah. But also, I think, it is, if I were a church-going person and we were in church, I would look around and say, it is good to be here. Right. After 2 years of not having people interacting in person, it is really fantastic to see you and welcome. So the panel that we have at the moment is going to be looking at competition law developments in Africa over the last 2 years, right? It has been 2 years. I know it doesn't feel like it's been 2 years because we've all been sitting at home and eating a lot, but it has been 2 years. And so that's what we'll be talking about. So just to introduce the members of the panel. So I'm Golani, I'm a partner in the competition practice based in Cape Town. I've got Raphael Muru, who is the head of mergers at the Competition Authority of Kenya. Then I've got Walia, who is our partner in Zambia, Lusaka. We've got Dr. Mwemba, who everyone knows, the CEO and director of the COMESA Competition Commission. And then we've got Adalberto, who is from the Angolan Competition Authority, who we're very excited to welcome to South Africa, the new kid on the block. And so we'll hear from him what's happening in Angola. So without wasting too much time, I suppose, is to start off with what has been happening in Kenya over the last 2 years. Rafael, over to you.
Thanks, Sax. And thanks to Bowmans for this occasion. It's good to be here back. I'd say for everyone after 2 years. And I would say it was such a beautiful experience at the airport. I think COVID has made us more African. That within one click, my passport was stamped and I was through to get into South Africa. So that's a really big plus. And I hope it would continue in the same manner. And in the last 2 years, there has been great development in Kenya. First of all, I would say, I think Competition Authority of Kenya has become mature, 10 years. Now, I don't think referring to us as a young agency anymore would really fit for us. There are other younger agencies in Africa and globally. And the first element that happened just before COVID was competition general rules that came into place at 2019. And a key element of that was the merger threshold guidelines that from the last discussion we had here, I think we were still discussing with COMESA and saying we are very strong in discussions in terms of eliminating double notification, which would be very glad to say that we have eliminated that. And then another key development was that from the thresholds, we were able to create an exemption of certain areas, certain block of transactions that's below 5 million USD, which I believe is a very key component of starting growth and development, especially for SMEs in the country. And from there is that as much as we are doing this, I would look at it both ways. As much as we are eliminating the double notification at the moment, what is also happening for us? Tripartite is coming in, CFTA is coming in. We also have EAC is coming into place. So as both as competition agencies and also as stakeholders in this, what are our perspectives in terms of ensuring that we don't go back to the same pit, that it's likely to happen. We cannot wish that away, but we have to be alive and ensure that that is not happening. Then from there is that during this period, the Competition Authority launched its strategic plan, that strategic plan. This was purely envisioned and done during the COVID period, and it was done in-house. For once is that the agency felt that we no longer need experts. We are the experts. We sat down as a team inside there and developed a strategic plan, which has a clear broad mandate of expanding our enforcement frontiers. And what we mean by this, we are looking at new areas of cooperation. We are looking at digital economy, which are the things that are driving whatever is happening right now. I'll take an example of like Kenya, where we find that during COVID and post-COVID, there was increase in person-to-person mobile payments by over 50%, actually by 53%. So where do we come in as competition regulators in such elements? So we are looking at those areas critically. We are also looking at the area of cooperation. As you look at the economy, the markets are really shifting. We are moving away from the traditional market that before COVID, we could see a steel manufacturer only relying on making phone calls to make delivery. Nowadays, their customers are going online, placing orders, and orders are actually being produced from that online platform for the orders for what is required specifically. So are we just looking at the traditional steel manufacturer, but now there's a clear platform they are using to deliver their goods? A key component of what we see in online pharmacy and food delivery, which I find it's cutting across even in South Africa and other countries. That before I had to walk into a pharmacy, walk into a chemist to order for medicine. This is changing. So in the strategic plan, these are some of the areas we are looking at. And I was very glad to listen to the giant actually point out that this is not just purely a competition issue. It will not be looked at as purely a competition issue. There are elements of data protection, there are elements of telecommunication that it requires collaborative approach, is that competition authorities will not provide solutions for these challenges alone, but they can be drivers because they also have a clear, bigger approach and understanding of what is happening in the economy. Rather than being a sectoral regulator, is that they cover all sectors. So it will require a more broader approach towards that level. The other element I would say that we are looking at, which will be a major development, is that as a Kenyan Competition Authority, we are trying to simplify our merger notification, and this is an area where we require stakeholders to really come in with their input. I would indicate that before COVID, we had already started testing our online systems in terms of filing online, and I would be glad that when people closed, I remember I was getting phone calls that, can we make a notification? And I was telling people, yes, go online. We are available. We never closed, actually. I believe we're one of the agencies that never closed even a single day because of COVID, and that we really take pride in. However, moving forward, we are trying to simplify our merger notification, and our target, I believe, as the head of mergers, I'll be very happy to have the simplest merger notification globally. That would be a very big plus, but it will be more data intensive because we look at our analysis now is not going away from the narrative. I don't want you to explain to me, as what has been described by the judge, we are looking at public interest in terms of pure analysis competition-wise, not just looking at a narration and telling me that likely not to affect employment. So how do I analyze that? We need the numbers. So we'll make our analysis more data intensive, but also simplify what you put in so that if you go to do a filing, you're able to put in your data very easily for that. The other key perspective that has happened over that period is the development of joint venture guidelines, which also I believe we are a pioneer in Africa and globally. And we are trying to provide more clarity. We have seen over COVID period that companies are no longer coming together just to merge, but they are looking at areas of building each other. You're finding a bus company coming together with a hailing up to try and deliver more, move more passengers and move more people. So instead of them coming together and forming one company, they're looking at areas of collaboration. So we are trying to provide better clarity in terms of what we consider full functioning joint ventures, how we consider the thresholds for that. It might not be a very rosy road at the beginning, because also we are trying to come up with clear interpretation of what we have. We'll have back and forth between the stakeholders and ourselves. But I believe from that pioneering, and I'm seeing even the other competition agencies globally are really getting interested in what we are doing. And then from there is in terms of also whether some of the joint ventures would fall under RTPs. And a key component of our guidelines is that in terms of JVs, we are requesting parties kindly seek advisory opinions for this. Rather than actually implementing and saying that the guidelines have given a full description of these, we are offering the advisory opinions for that for free. And then from there is in terms of digitization, I would say that the authority is also going further forward Now this February, last February, beginning of February, we just launched our mobile app, which is still also undergoing upgrading. The key elements of this is that the authority deals with both competition and consumer issues. So we are looking at better times where people can report RTPs anonymously more easily. Companies can make complaints, consumers can make their complaints. When you file your mergers, you're able to track. You don't have to call Raphael when he's on leave and ask him what the current status of the merger is, that you can go online and see you have now a complete filing, your 60 days account has started. So you just need to check, unless now the app is not working, which has been unlikely for our systems, is that you're able to track yourself and have feedback on your case, that you know by this day, if at all we have moved forward, the determination will tell you by March 20th, expect the determination of your transaction. So those are some of the changes that we are seeing and what we are looking forward to as Competition Authority.
Fantastic. Before we move on from here, just two things. If you can just talk to us through sort of the CAK's current practice of thinking regarding penalties and criminal sanctions, both from a mergers perspective and an RTP perspective. And then to just close off is on market surveillance and detection of non-notified mergers.
Thanks. In terms of penalties, I would say the authority has grown full board. We have grown fully mature. We have come up with the penalties and finding guidelines that cut across all our illegal practices. I would consider that elements that are anti-competitive, consumer infringements. We have collapsed all the penalties and everything and fines that are covered in the Act under one document. And the main reason for this is to provide a one-stop shop. And from where I started that, we are 10 years old now. I would say right now, we are no longer saying that a company would come in and say, we are not aware of the competition law in Kenya. It's no longer not being aware, but it's now purely ignorance for you not to be aware that you can't go and seek legal counsel on someone and that you're not looking at competition issues. These issues are all over the media, they're all over you. So as a business practitioner, it's now no longer just you whisking away that we don't deal with competition matters. Over the last period is that we have penalized companies even during the COVID period. I wouldn't go to mention the exact names, but what we are looking at is more compliance we expect more compliance from stakeholders. And also the main challenge we find is that when you're caught on the wrong, sometimes it might be of pure ignorance. I find that there are companies that have been on the wrong because not the management knew about it, but as a simple employee who was doing something that actually went on, and I, as the owner or the business owner, I'm finding that, look, we're increasing our profit, so let's continue with this. So it's not always that because you're caught on the wrong, that you have to prove you're right. You look for all ways of proving that you're right. And we have found that companies have still been penalized and have gone ahead and still grown in the economy. And they have also become ambassadors of competition law, which I find it to be a good perspective. In terms of detection, we have really grown that we are no longer relying on the old traditional ways that someone would walk in and say, I'm suspecting this. We have seen cases whereby parties have been trying to comply with a matter that has already been implemented, for instance, for mergers. Now filing like it's a fresh notification, which I find to be very, very, very wrong. It's better you come clean and say this one was implemented and then you can move forward. In terms of RTPs, I would say over the COVID period, there was a bit of lax because of the way of you can do the don't raise the key parameters of what you do with the investigations. However, we have been able to conduct certain investigations, which I believe in the next 6 to 10 months, you'll be hearing of what you have done in it. So we are really trying, and we're not just after penalizing. What we are looking at is, are you complying? Is the economy benefiting from our actions? Because I would not feel very bad to say, yeah, we penalized the company $1 million USD, and yet the ordinary consumer is not benefiting from lower prices, is not benefiting from innovation. So our whole purpose of the regime is actually to ensure that consumers, by the end of the day, benefit from what you're doing.
Sure. Thanks. I know, I said it was going to be the last question, but I did talk about church, and so we'll do a church thing here. Questions keep coming. Final one is just, you when we're preparing for this, sort of mentioned about sort of arbitration. That is part of the process that the CAK is introducing in dealing with penalties. Can you just talk us a bit more about that?
Yes, in terms of arbitration, is that with our judicial system, it's really focusing heavily on, because our way of sanctions covers both ways. There's a penalty process, and also there is also the criminal sanctions that can be done. And we have seen instances where we have tried to impose criminal sanctions. And what also the authority is looking at is really rather than going the whole criminal way, is that as a judicial system is trying to be very strong on settling, especially such of these economic issues in terms of arbitration, is that can we have arbitration take first role after the matter has reached that level? But we still take penalty as a first landing spot, and it only goes to criminal mainly when we find there's some level of resistance in compliance. So for instance, if you have asked for your submissions and parties have completely declined, so we are left with no other option than that we fall in for the criminal option. But also a key thing I would say is that we have seen also parties really taking up the tribunal way. And this has gone even when matters are halfway, matters have not been concluded. We have seen this, essentially this is really helping to strengthen the competition enforcement in the economy, that you find the decisions, some of them even, I would say one of the elements that we are very proud as an agency is that the decision that we make is now made more public, because at the tribunal, the matters are open for everyone to scrutinize and have a review of them. And once the stories are being picked up from that level, is it helping enforce the competition law? And I'm finding that the matters going to tribunal, parties are also willing to come back and actually set on those matters. What I would say would be critical is that parties should not think of using the tribunals for forum shopping, that I want to delay the matter as much as possible. I know X will not be happy for this, that you want to make more money as a lawyer. So you go to arbitration file, you go to the tribunal, then come back, you'll still come back to CAK. That the faster the matter is concluded, the more it's beneficial to the public. The more of dragging of the matter does not benefit the public at the end, because it's not the competition authority against the company. It's more of, are there issues that your consumers could have been benefiting better? Sure. Could they have been enjoying better prices? So for us, anytime delay is actually justice denied to the public, rather than it being the reverse of it. We see it not being as like we won the case, but for that one period, the matter was going on. Did the consumers benefit from lower prices? Did they get inferior goods? Right. So that's our main worry, that even at the tribunal level, we are trying to have the matters cleared as soon as possible, so that the benefit can be accrued to the public.
Fantastic.
Thanks.
Walia, let me come to you. I mean, the competition authority, CCPC, has been quite active over the COVID period. Can you just update us on what's been happening there?
Okay. Thanks, X. Yes, indeed, the CCPC has been quite active. And if you're aware with the type of work that they do, they have been quite an active enforcer of competition law in Zambia. And during the COVID pandemic, we definitely saw that they continued with their operations. So for example, on the merger side, they started to allow for electronic filing of applications. So it was one of the commissions that did not have any disruption to its services. They also continued with investigations into various restrictive business practices, as well as abuse of dominance. And what was actually impressive to see was them actually being cognizant of the fact that we were in a pandemic and how that was actually affecting businesses going forward. So you will find, for example, that they had an increase in investigations in abuse of dominance. And that was because I think they had an increase of complaints relating to excessive pricing. But what we did see was that 18 enterprises were said to have abused their dominance in various markets. But the CCPC did find, following investigations, that the conduct of these enterprises was actually justifiable in the circumstances. So one of the cases, for example, was in relation to an ethanol supplier who was alleged to have been excessively pricing ethanol. I think the price was alleged to have been initially $1.9 per liter. And then I think the allegation was that the price had increased to $7. When the CCPC did conduct its investigations, they found that actually the price was $3.90, but it was a justifiable increase because of the pressures that the supply chains had suffered during this pandemic period. And Zambia being an import-based country, we saw the supply chain being greatly disrupted and it affecting the output of various businesses. So for example, I think in that particular case, there were arguments being made that the importation of ethanol on an airline was no longer the same price because we had limited airlines flying into the country. So that was a positive way of seeing how the CCPC was integrating the results of the COVID-19 pandemic into the ongoing businesses and the pressures that businesses were actually facing. Generally, what we also saw was a reduction in mergers. I think there was generally more regional mergers, but there was a reduction of mergers in Zambia. Because unfortunately for Zambia, in the past 2 years, in addition to having the COVID pandemic, we also had almost like a recessive economy. And that was because I'm sure some of you might be aware that we were, defaulting on our sovereign bonds. So the state of the economy was quite poor and foreign direct investment was not coming in. So we saw that impact on mergers. But at least we saw that on a regional basis, and I'm sure Dr. Mwemba will speak to this, that there was actually an increment on that. Generally, on restrictive business practices, there was a reduction in the cases investigated by the commission, but they attribute it to having an increased awareness by businesses, which is great. But what we also saw is that there were a lot of investigations into cartelistic behavior. So some fish fingerling producers, 7 of them were actually fined for cartel behavior, because I think there was price fixing in the manner in which they were doing their business. The CCPC found that there was no justifiable reason as to why they needed to collaborate particularly or have similar pricing. So we saw those 7 producers being fined. One of them was fined 10%, the others were fined 9%. It is not clear why one was fined a higher amount. We also saw cement companies being fined. In this particular case, we saw, and this is in the public domain, we saw Dangote take advantage of the CCPC's leniency program, which is something that is out there. They have been urging businesses to take advantage of that, where there's any restrictive business practice going on. So they took advantage of that, and as a result, Lafarge Cement and Mpande Limestone were both fined 10% of annual turnover. We understand that these cases are currently on appeal, but those are some of the cases that the CCPC has been dealing with on the restrictive business practices.
Super. So can you talk us through, I mean, what's the CCPC's approach at the moment to exclusivity?
So the CCPC's approach is that they see exclusivity as being an issue, in the sense that it is allowable if you can be able to provide a business justification for exclusivity. However, what we have seen also, and this segues into agreements and seeking authorization. Arising from the COVID pandemic, as well as the state of the economy, the CCPC has been enforcing the provisions of Section 14 of the Act, which require businesses to obtain authorization and approval of their agreements. And in as much as the idea is to ensure that those agreements are not anti-competitive in nature. So what that means is that if you have a horizontal agreement and you collectively in that agreement supply 30% of the market, or you're acquiring 30% of the market, you must then seek authorization from the CCPC to proceed with your agreement. In relation to vertical agreements, the threshold is reduced to 15% for each individual party to the agreement. Supplying or acquiring, you then need to obtain authorization. And what we've seen is that the CCPC has taken quite a broad interpretation of authorization under Section 14, which basically means that should you have, or should you meet that market threshold, then your agreement should be subject to authorization. We obviously think, we don't agree with that interpretation, because it would then mean that for players that have, or that meet certain thresholds, they might then have to notify almost all their agreements that they're entering into, which I think probably is against, is probably not business efficient. We hope that they'll definitely clarify these later on, and we can have guidelines on that. But when we speak to the CCPC, they basically are saying that if your agreement has any exclusive provisions, for example, that would be critical for you to seek authorization, because then what that does is that it reduces or mitigates any potential action that might come later in relation to whether you have actually been involved in any restrictive business practices.
Right. So, I mean, similar to the CAK, the CCPC also has a dual mandate of competition and consumer protection.
Yes.
And I mean, what we're seeing, what Rafael is talking about is that part of that has led the CAK to really up its game in terms of digital tools available to it. There's an app. I mean, I think they're trying to put Facebook out of business. But so what has the CCPC been doing on the consumer protection front, as well as sort of genuinely digitizing?
So they have recognized, the CCPC has recognized that they need to digitize their operations. We haven't gotten to a point, I think, where Rafael and the app, we haven't had that yet. But so far, what we do have is complaints can be made, and I'm not sure that there are any restrictions on the delivery of the complaints. But when it comes to consumer protection, there has been an increased awareness from the public on their rights under the competition law, which also houses consumer protection. And what they have seen is an increase in the number of consumer complaints, such that they have almost 3,000 cases that they have to deal with relating to consumer protection. The CCPC has indicated that as part of their growth, they need to digitize as well as increase their capacity, because I think carrying out investigations in the various spaces is also, they're also noticing that a lot of the information is being housed digitally, and they need to be able to increase the capacity in able to deal with those challenges.
Super. And what are the CCPC's priorities for this year?
So the CCPC's priorities for this year, the way we see it is, as I had mentioned, authorization of agreements to try and prevent restrictive business practices by players actively seeking out the authorization of the CCPC. And just as Rafael had mentioned, I think what they are trying to do is to encourage compliance over trying to penalize parties, which is a huge positive for us on the part of the CCPC that has quite some heavy fines. But also consumer protection is key for them as well, in light of the awareness by the public, but also the number of complaints that they do get. So this is an area that a lot of businesses have to be aware of, because you'll find that the nature of complaints sometimes will border on contract and the breach of contract, but now you have the intervention of this consumer protection law, which in addition to any liabilities that you may have under contract, you then are liable to a potential 10% of annual turnover as well for a breach of a consumer protection right. So I think that's one of the things. And maybe just to also mention, so I think the CCPC tends to have quite a seamless interaction with the Commercial Competition Commission. And I think they've never had any formal legal provision supporting that relationship. I think they have an MOU. But what we have seen, and I think the indication is that they intend to domesticate the commercial competition regulations, so that relationship is then supported by the law. I think there are a couple of lawyers who have tried to argue in the past that that COMESA does not have any jurisdiction in Zambia yet because of the lack of domestication. But I think because of the relationship between the CCPC and the Commercial Competition Commission, we have still been required to notify regional dimension mergers to the COMESA Competition Commission. But the idea now is that it will now be backed by law, and we definitely are looking forward to that as well.
Sure. I'll skip Dr. Mwemba and go to Angola first. Now, I mean, Angola is the new kid on the block, and one of the it's a similar, I suppose, to a lot of the regulators here. It is a regulator that is open to having conversations with business as well as lawyers. But one of the, I suppose, early criticism of the regime, at least from a merger control perspective, has been how formalistic it is. When you file a merger, there's this thing called consularization. So can you just talk us through the institutional structure of the ACA, its approach, and why it actually has to be as formalistic as it is?
Yes, thank you. It's a big honor to be here, and for the first time. I ask for pardon because I will have a delay to speak, because I think in Portuguese and then I translate to speak in English. So sorry for that. Another thing is, for us, all we do in Angolan Competition Authority, it's a development, because we are very young. We have only 3 years, 2 of them with COVID pandemic. So every step we say, hey, we are here. So we have a news. The first one is that we are transforming in an independent agency. So now we are inside the Ministry of Finance, and we already have the order, and we are working in papers to send to National Assembly, first to the President and then to the National Assembly to approve it as an independent agency. So this could be a great opportunity for us, because we are struggling with another economic politics in the government. One of them, for example, is the privatization process that is in course. And when we try to help them to make the term of reference, to choose the better companies, that doesn't limit the competition. But sometimes it's not easier, because the another agency wants to receive money quickly with the companies interested in assets, but we are looking for the market, and this can be confusing. Another political issue that we had in the past, but we are surveilling, was a local content on oil and gas sector. We helped them to drafting the rule, and after that, we struggling to see the list of companies and products and services that could be in this very, very closed market. And this could be great for us pulling out of the government. Other problems that we are facing is with financial recipe. We only, in the past, quite a year ago, we received a fees for the measures, but in the past, we only count with general money for the government. So it's a few, because Angola is now in struggling economic and financial problems, and these make problems to us. And we are trying a model of financing that the other sectors, regulators, pass by a little recipes for the companies that they ask for licensing and authorization and pass to authority, because we have transversal powers with all markets. We are also in about 2 years ago, we approved our form that is very long, as you already said, but we have a formal procedure that companies can ask with a few information informally if they need to notify or not the operation. So this could be more easier to the companies and only fill it the long form if necessary. Another thing is we are trying to make digital our process such as notifying. We are in trying version of notifying mergers, and also to report antitrust. It's very important to us because the two big investigations in antitrust are coming from reports for other companies in big sectors, and we are closing the investigation. We already closed the investigation process about 2 years, and now we will accuse the companies that we investigated. So it's a short.
So I mean,
Yeah.
the sort of, which is unusual, I think, for most regulators. I mean, the ACA at a very early stage started to and published guidelines for a number of areas. Can you just talk us through that and the thinking behind sort of right off the starting block, already putting in place guidelines?
Yes, we are. This is other problem. We are facing problems to understand what is our work on the market, because some regulators think that we are robbing our powers, and it's very difficult sometimes to articulate. There is a few regulators that are more openly to the Angolan Competition Authority, but some of them are very, very hard to us, don't cooperate, and sometimes make a political treatment. So it's very complicated sometimes, but we have a big program to interact and making protocols to give information and receive for them, because some of the sectors are very, very complicated, such as electrical sector or oil and gas, and we need them to understand the market.
Okay, so I think let's go to COMESA and we'll come back. Dr. Mwemba, you've been very busy. We said it was mentioned that COMESA has now imposed its first penalties. I don't know if the new broom is sweeping. So can you just update us, and I mean, and also for you personally, it's been a new journey, right? You've just started as the CEO and director. So how so the last 2 years also start off and coincide with the start of your tenure. So how has that been?
Well, quite an interesting question. Obviously, yes, the last 2 years, the beginning of the last 2 years is about me. The first thing is the last time I was here, I was a very young man. So I'm coming back here as a very old man. That's what has happened in the last 2 years. So I was chatting with Tamara. Initially, they had put my picture on their LinkedIn profile. Very young, handsome me. Very, very young and handsome. So even when I saw that, I was saying, but this is my name, but who is the guy here? So I was telling Tam that this would be very misleading. People would have seen that picture, and when they see the real me, say, but it's not that old man. So that's what has happened to me, obviously, in the last 2 years. And of course, as you said, the last time I was here, I was the head of measures at the commission. I'm now the CEO. So yeah, quite an interesting journey. But when you get to the commission itself and its work, what is it that has happened significantly in the last 2 years? Before I come to that, I need first of all to caution Bwalia here that you see in the UK, Lord Denning cautioned businesses and lawyers. I don't know if that caution still stands today, looking at what has happened with all this Brexit and everything. But Lord Denning said businesses, UK businesses who question the supremacy of the EU law do this at their own peril. And he stated that this EU thing, this EU law, is like an oncoming tide. It flows down the estuaries and it will engulf all those that are resisting. So it's the same thing with this business of COMESA, member states. I think we should be moving past that now. We've moved beyond COMESA now. We are even talking about the tripartite. We are talking about the continental free trade area. So those are some of the bigger things that we even come bigger than COMESA. So I think it's high time we accepted this is the trend in the world. And one of my board members from Kenya actually last week taught me some very good terms. He talked about, Sunday, what did he say? Robotic what? robotic justice and substantive justice. He said, look, even as lawyers, let's stop these things of finding technicalities to challenge the whole thing. Let's be looking at the substance and the objective of what is happening and why the law exists. So I thought I should caution Bwali and the Zambians on that, yeah.
No, we're always on the same page.
Exactly.
We're always on the same page.
Now in COMESA, in the last 2 years, Tolani, I think our approach has changed. As you may know, previously our approach was very soft, and we used to call it soft enforcement. So we were more on awareness raising, more on when parties are on the wrong side of the law, we would bring them, talk to them, and then see how we address their concern. I would call it in the best interest of the parties, not in the best interest of the commission, of course. But over the last 2 years, we thought we have done quite a lot now. Everyone, as Rafael said, in the case of Kenya, everyone should know about the COMESA competition regulations and the COMESA Competition Commission. So it is now not business as usual. Where there's an infringement, we have to talk to parties. Where there is an infringement, we will whip. That is the position, and that's why you have seen the fines that you're talking about in one instance where parties failed to file the major within the required period of time, and that to us there was no excuse for the parties to have failed to do that, because as you may know, most of you in here, the lawyers in here, we've been very we've had a very relaxed approach to that 30-day period. We've said, as long as you've engaged the commission, whatever engagement has, even an issue of high sandia, we have a major that will be filing in the next 3 months. That's the beginning of the notification process, and it cannot be more lenient than that. So if parties, even with that very relaxed and lenient approach, still fail to file the major or even engage us, we find that to be blatant disregard of the regulations. And we thought some sanity should begin to come in the market. So those parties were fined. And then the other one, obviously, it was a breach of the undertakings that the commission received. I would use the word received because the undertakings were given by them when we identified those concerns. They went back to the market and thought the undertakings were just a formalistic, casual thing to sign. And they went to the market and did the exact opposite. Obviously, again, that's a blatant disregard of the law. And we are saying, we'll not continue with business as usual, where I would have called them and said, no, you've done this. We think you should do it. We needed to show that such will not be tolerated anymore. And obviously, from that comes in another point I would want to share, that we've enhanced our transparent mechanisms and framework within the commission, where you have decisions made by or recommendations made by the investigative wing of the commission are actually sometimes overridden by the decision of the CID, and also where decisions have been made by the CID are appealed to the appeals board of the commission. So for example, in the case I'm talking about on the breach of those undertakings by those parties, the commission had actually recommended a very hefty fine, but the CID disagreed with us. They put in a lot of their reasoning why they disagreed with us, and I think they reduced the amount to about half of what we had recommended. So we were not happy, obviously, but that shows something also within the commission, that there is some kind of separation of powers, independence and accountability, that we can't just wake up today and say, Derek, you've done this wrong. You have been fined $1 million, and that is what caused. So Derek, even before he appeals, the CID, our own CID, would review that decision or that recommendation and agree with us or not, I think, which is a plus. In terms of the CID itself, even them, their decision is not final. So we've had situations where the CID has made decisions on some of the undertakings, and those decisions have been appealed to the appeals board of the commission, and we await the outcome of the appeals board to see if they'll agree with their CID or not. Yeah, so I think some of those are the things that have been happening in the last 2 years.
Yeah, and I mean, I suppose, I mean, Walia also mentioned that Zambia is looking to domesticate the COMESA competition regulations. So are you seeing a lot more sort of harmonization within the COMESA region and more member states seeking to domesticate the regulations?
Yes, absolutely. So, for example, we have a project with Mauritius currently, quite a huge project with them, where we are reviewing the legal framework in Mauritius, and then to also making sure that it expressly, and I should be very clear here, when we say we are reviewing the framework in Mauritius so that it expressly gives effect to the regulations of COMESA, it does not mean then that we are saying, or you should go and say, I said, then the regulations have no force there. But it's exactly to address what Walia is bringing here, so that in the future, this conversation is done and dusted. So we have that project with Mauritius. We have a similar project with Djibouti. I was just with the Malawian Competition Authority at the office. Today is Thursday. Yeah, I was just with them at the office the day before yesterday on Tuesday. So we've begun the same talks with them. You talked about, did you talk about it or I read, or is it Derek? Yes, Derek talked about the Malawans obviously looking at the amendments to their law. So we are working together with them on that one. In fact, it's a project that we will support and fund. And those are some of the issues that we will come from that project. And then we have other countries like the DRC, where we've done quite a lot of work from establishing. I think most of the work started around 2016. Most of you may not know, with the commission helping them. They're at the stage where they are almost functional today. And the issues we are talking about of domestication and what they don't arise there. And yeah, Tolani, I think we've been asking me what is the state of the DRC Competition Authority and their operation. And I think I told you that in as far as I'm concerned, they say they are operational, but I think there's still a number of things to put in place before they become fully operational. So they had visited me as well. I think Tuesday was a very busy day. They had visited me as well over the weekend. I was with them up to Tuesday. And I posed that very same question. I said, lawyers are asking me what is the exact position, even if I know that I've been holding you by the hand to make sure that you become operational. So I said, no, look, we are operational. But so if someone brought a major today, would you be able to receive that major? I said, yes. Do you have a major notification form, for example? I said, you need to help us on that. So then I said, okay, then we have a little bit of some work to do. Yeah. So the institutional framework is there, but I don't think I would be comfortable to say they are operational. They are yet to be fully operational.
Right. And then, I mean, I suppose similar to Zambia with the Article 14 process of authorization.
Yeah.
COMESA also has its Article 20, is it?
Yes.
And so what's the thinking around that? Is that something that the Commission is now wanting to really push forward as an avenue that businesses should be using?
That's a very good question. And in fact, it also forces me to reiterate the point I'm talking about. Whipping children that are very disobedient. You say even the Bible says, spare the rod and spoil the child, something like that. Yeah. So our Article 20 actually is a very good tool. In fact, there's a big difference between our Article 20 and Section 14 of the Zambian Act. So our Article 20 is not mandatory. It is not mandatory that when you enter into these agreements, then you should approach the Commission. Okay, it's very voluntary, unlike their Section 14. And Derek will agree with me that there was, I think, a transaction that we were looking at. I think it involved MTN or something. I told you I'm becoming an old man now, so I don't remember some of these cases exactly by name, but I think it involved MTN, and it was some kind of joint venture or something like that, an agreement, which from our side, we said, in fact, from our side, we offered an advisory opinion. It was not even an application under Article 20. So from our side, we said we don't see anything wrong with this. I think it's a transaction that can proceed. But the Zambians, because the Zambians actually referred that case to us. So it was not Derek bringing it to us. It was the Zambians who referred it to us and thought it had the regional dimension because of MTN has operations in a number of countries. But when we looked at it, we found that there were no issues from our side. But then the Zambians wrote to us and said, well, if you find no issues from this, then we'll pick it because COMESA has not picked it, because under section 14 for us is mandatory that these people should notify. They could have only escaped notification if it was considered by COMESA. So our Article 20 is voluntary, but where parties are not so sure really, I think it's important that they take advantage of that Article 20 so that once the commission gives you its position, a go ahead, tomorrow they will not come back and say this is an anti-competitive agreement. And if it's a door that is voluntary, why not use it? So if you fail to use that door and out of our own volition, we find that something is wrong, then we'll remind you that Tolani, you should have come under 20, but you neglected to do this, and you pay the consequences for that conduct. So it's something that indeed we're encouraging parties to take advantage of. Yeah, because obviously it assists them in an event that something goes wrong in the market later on.
Sure. And I mean, you sort of mentioned that Zambia referred a case to the CCC. So are you seeing more and more referrals from member states, whether it's from a merger context, RTPs, and also vice versa, where the commission has either open investigation or has received a merger, the member states say, no, bring it to us rather than that the commission review?
Yes, of course. We've seen in the recent past quite a number of cases that member states have referred to the commission because they thought there was a regional dimension there. For example, it's an active case, so I'll not give a lot of details. But for example, we have one case we are looking at in the shipping sector, and that case was referred to us by the Mauritian Competition Authority, and I think the Kenyans also know about it. And so it was referred to us by not the Mauritian, Seychelles would, Mauritius is Mauritian, Seychelles would be what? Seychelles, that word. So from Seychelles. Yeah, so we have a number of those, Egypt, and I think Egypt is an interesting case. I know Tolani, you have a question on that, but Egypt has also referred quite a number of cases to the commission, both mergers and restrictive business practice cases. The opposite is also true, that the commission has, in instances where it thought it had no jurisdiction on a case, referred it to national competition authorities. We've done that in the past with Mauritius, we've done that with Zambia, we've done that with Kenya, we've done that with Malawi. In fact, we have one current case now that when I get back to the office, I'll be writing to the Malawans that this should be your case. So we are doing that as well. But from a major's point of view, I think it's very important, and I think Sandia yesterday mentioned that in her remarks. From a major's point of view, the sad part with our regulations is that it gives member states an avenue to call for a referral of a transaction where they think that transaction would have a more disproportionate effect in that country compared to the rest of the common market. And I think a number of countries have used that before. Kenya has used that before. Zimbabwe has used that before. Mauritius has used that before. Zambia has tried I think 3 times I rejected that. Yeah, because I didn't see much merit, but maybe I've been very hard on the Zambians, I don't know. But I rejected that on 3 occasions. So from the member state point of view, the regulations provide that avenue for them to request for that referral, but we cannot voluntarily refer a major's case to a member state because our law does not give us that power, which I think is a little bit sad. But I think, as she said yesterday in the proposed amendments, we want to make it very clear that even us can refer a case to a member state without waiting for that member state to request for that referral. So sometimes they may not know about they may know about the transaction, but they may not have much more details as we would have if we've received it for them to trigger that Article 24.8 of a referral. So we may have much more information that they may not have. So we should have that authority to refer as well, where we think Zimbabwe, for example, will be the one to be affected much more than the rest of the common market.
Yeah. So I suppose, I mean, this will be a question to all the regulators here. So I'll spare my partner, Walia.
Thank you.
So I mean, one of the things that Tamara Paramu mentioned yesterday was the amount of time she spends on the call, on the phone or email with the FTC or the European Commission, but none with any really of the other regulators in the continent, right? So why do you think that's the case? That there hasn't been a lot of collaboration between competition regulators in investigating cases, or whether are we going to start seeing that?
And I want to be very careful here because I'm in South Africa, right? But I think Tamara's comment yesterday should be a little bit more specific to South Africa, not talking more to the other regulators in Africa. Because to the best of my knowledge, I think we chat a lot with Rafael. Mr. Francis Kariuki, the Director General of CAK, will be coming to Malawi to see me on the 1st of March. And among the issues we will be chatting about how we collaborate more, how we investigate cases together. Mburu, the last time I was with him in some conference, I can't remember where it was, an online conference. I recall him saying, don't be surprised if you see me at COMESA reviewing and working with the colleagues at COMESA Competition Commission, reviewing a major, because those are some of the things, for example, we've put in our MOUs where staff can be at. So there's quite a lot of, and maybe Mburu will say that, and then my colleague from Angola. But from the COMESA competition point of view, we think there's a lot of interaction with national competition authorities. And I think there's a lot of interaction between competition authorities in COMESA, not just with the COMESA Competition Commission. So I think, sir, it's South Africa that should up its game to engage more with other competition authorities in Africa. But maybe Mburu may have something to add on that.
Thanks. And from a Kenyan perspective, I would say see it in two ways. First, the heavy reliance on the likes of US, the West, and FTCU is because of, first of all, you're looking at technical experience. You find when you're a young agency, you're looking at them as big brothers to actually assist you in some of the matters that have been handled before. So that cooperation could be seen to be very broad. And also because of the resources the agencies have there, you'd find they're spending more. Their international relations is more towards training staff and equipping them with skills. But as the agencies in Africa are growing, we are moving away from relying on them to actually now being interagency cooperation, where we are assisting each other to build on cases. The amount of times Kenya has cooperated with South Africa, every week, I believe we have an email from COMESA, we are dealing with the matter jointly. So it's now moving away from EU and actually understanding that our challenges in Africa are our own unique challenges, that we have to get our own solutions. If I look like now at the digital economy, whatever is happening in Europe is completely different from what we have in Kenya. I've always come from the school of thought, like, if for instance, there was no Android in Kenya, how many people would actually have 5G, 4G network? How many people could afford a smartphone? The switching cost of $50 is enough for me to buy a new phone. Can I move from iPhone to Android very easily? No. So I'd find the challenges that are there in Europe and the West are completely different from what we have here in Africa. And we have to get our own solutions for our own problems. So we can no longer copy paste that. So I find even the times we are in, will not actually be, it's not us to change from relying heavily on them, but will be forced by circumstances. That it's better for me to rely on what is happening in South Africa and Kenya, because even the companies moving from South Africa to Kenya, CFTA is happening. So there will be more regional integration across board, tripartite. Yeah. So we have to really focus on ourselves rather than seeing from that region. And also now, I believe Kenya now is becoming like also a big brother. Angola, we are already, I think there's something being talked about. Congo, we are going there. We're going there. We'll have joint trainings to assist them to set up. Ethiopia had in the past sent its experts to come to Kenya for, I think, 1 month for training. Yeah. So we are finding more of collaboration locally rather than us thinking of going outside the continent.
Yes. Yes. From Angola perspective, there is two issues. One of them is the language. Another one is the legal system, because we are in Southern Africa and our system is Romanic and you have another law system. So we start with Portugal and Brazil because of the language and it's easier for us. And also the Portuguese authority, maybe that we are so formal, ask to us in the first year and invite the boards and part of executive departments to training us. That was very important to us. But we also are connected with another regulators by the informal networks such ICN and AFC, where the first time I knew Raphael in Gambia. But also we are trying to make a protocol with South Africa Competition Commission. We are discussing the drafting of the protocol, but it's our priority in the region. Also, we have a program for this year. We stopped because of the pandemic and to ask for workshops, inviting people from other authorities, especially the older ones, and also send our people to training.
I think we'll open up to the floor. We've got, I think, 15 minutes and then for questions.
In listening to Judge speaking and Derek, I was reflecting on something that we've had debate before. And this relates to an ideal situation versus practical issue. So where I'm coming from is that we currently, the world over, we are in a VUCA world, right? And parliament, governments are focused entirely on emergencies and things that are coming up. Competition law is hardly on the agenda and is unlikely to be on the agenda for a long time. They have, as governments, bodies like Competition Commission, et cetera, to look after the interests of the public. And therefore, in the approach to interpretation of competition issues, I'm hearing, oh, we want Parliament to be more explicit, Parliament to do this, so that the agencies just follow what Parliament has legislated. But the reality is that that's not going to happen because the focus is not on competition law, but on other issues. So my musings and reflection are leading me to say, perhaps we should be more tolerant and actually accept the reality that if we are going to be protecting the public, if our interest is the public, we shouldn't really be focusing on the technicalities, but rather saying, what are we seeking to achieve? And therefore, the debate becomes, how much leeway should the agencies have to achieve the objective that all of us agree on, as opposed to say, actually, the law says this and we must stick to it. And if Parliament doesn't do anything, then the public doesn't benefit in the long term. I don't know whether you are understanding what I'm saying, that there should be a lot more tolerance in relation to what the agencies are doing, because they are still an arm of government. Yes, they're not Parliament, but they're an arm of government seeking an objective that benefits the public. And therefore, whatever they do is an extension. But yes, it's not pure because Parliament has not quite legislated that way.
Okay.
Thank you.
George. Thank you. Before we answer that question, do we have another question?
Hi, I'm Ryan Hawthorne. I'm from Acacia Economics. I was wondering, we've been doing some work on the continent, and do you see much by way of negotiation around regional competition law enforcement, but from an AfCFTA perspective, the Continental Free Trade Agreement perspective? So I was just wondering whether you're seeing any sort of movement in that direction, whether you're seeing any negotiations towards a full Africa-wide regional competition authority, or whether that's kind of that's not really an activity that the authorities are really engaged in at the moment.
Sure. Yeah. I think it's a pity that the AU heads of state decided to hold a meeting in Addis Ababa last week, and therefore the Secretary General of the AFCFTA couldn't travel down. He was supposed to be here, but couldn't make it. He would have been able to answer that question, but the heads of state got in the way. They should plan better next time. So, but as far as I'm aware, yes, certainly the second round of the AFCA negotiations have already commenced, which include the protocol on competition. But at least as the intelligence we have is that there isn't a plan in that protocol for a continental regulator. And you can imagine, I mean, you just add another layer of complexity. We're still trying to figure out, COMESA, what the tripartite is going to do, how EAC fits in. And so there's a lot of moving parts at national as well as the regional economic communities, which are obviously key aspects of the continental agenda. So that, I think, needs to be sorted out first. But from a policy perspective, as well as, I suppose, sort of putting a continental framework, that's going to be in place, but not a regional regulator, unless anyone else on the panel has a different intel.
Well, I think you are right, Tolan. I practiced your name starting last week, and I was doing very well when I was at home. Until now, I can't Kalani. But yeah, I think you are right. And obviously, those talks are there, competition protocols under the tripartite and the Continental Free Trade Area. But there's no clear direction on whether we are having an enforcement model competition authority or simply cooperation. So those are things that are still in discussion. And in my view, I think we should be very careful with what we are doing now. We should understand the implications very well of what we are doing. I think we shouldn't be in a hurry to start putting things and signing things, which later on will start bringing debates on whether that competition protocol at continental level is binding in South Africa or not. So I think this time because you see, we shouldn't be so much in a hurry to sign things whose implications we don't understand. You're in a hurry to sign the COMESA treaty and the COMESA competition regulations. And when it comes, you're the same guy saying, no, wait a minute, it's not binding here. I find that to be very strange, to say the truth. I find that to be very strange. So I think at the continental level and the tripartite level, my view, and I think that's a cautious approach that countries are taking, my view is that let's understand exactly the implications of whatever we are going to come up with. If it is enforcement, a binding model, we should understand and implement that from day one after signing, not after signing, then we start changing colors. I think that would be my point. But I agree with what Tolani is saying.
Okay, and I think the remarks from George really were, I took him as asking the question, as regulators, do you feel constrained in any way to achieve what you believe to be the objectives of the regulator? Whether from that the law doesn't give you enough tools in your toolbox, or whether institutionally you're just boxed in, or whether there's just too much pushback. So I suppose that's a question for the regulators, whether you feel constrained somehow in achieving your objectives. Raphael,
I can go. I feel like I completely agree. There's no one single day you'll have all the laws you require to implement everything. It's more with what you have. What do you achieve with that? Like, I'll give an example of Kenya, where we are really focusing on using research and making proper papers for recommendation that actually end up changing regulations and law ultimately. A good example is we did a research jointly with Central Bank of Kenya into digital payment platforms. And one of the recommendations was picked up, and actually the amendments to the act happened through the Central Bank Act rather than the Competition Act. We didn't seek to get any powers, and we are seeing there will be benefits to it. I will tell you clearly that digital payment platforms digital lending platforms in Kenya have been really a real issue. That I would be seated here and I'm getting messages being told that Golani refused to pay his loan. Now, because I'm his friend, I should be telling him to pay that loan. And you have seen within 1 month of implementation of that, I'm not getting those phone calls. I'm not getting those messages. So actually what we wanted to achieve at the end for the consumer is actually being achieved without changing anything in the competition law, but taking it to the right place for it to be amended. So I find competition agencies really need to focus on research, inform on what is happening in the market, and see within their laws, what can they achieve first, and what is now what is lacking before you go for the amendment. I don't want to copy paste because the COMESA has this. I have also to achieve my law to look like this, but what have I done with what I have currently? I believe before we did our first dawn raid, there was so much back and forth that what does the law say, what are our limits and everything. And then until one day we decided, look, we are doing this thing. We are not waiting anymore. Let everything that comes with it. And still, even if we do then late 10 years down the line, I feel like there will still be legal challenges to it. But doesn't mean that you not be doing them. You continue doing them, and now you face the challenges as they come in. And so I feel like we have tools currently to achieve what you want. It's only that how do you make them be broad enough for you, and how do you get collaborators who can really assist you in achieving your goal? So because if today I want to push an agenda as just Competition Authority of Kenya on digital platforms alone, do I really reach the objective? No. But if I use Central Bank, I use World Bank, I use other people around it, is that their agenda is achieved even with faster and less resources. So it's more of a collaborative approach that really assisting on that.
Fantastic.
Yes.
Adalberto, what is the position in Angola?
We have a problem that people sometimes doesn't understand us. So, but we are making steps because this comes from political desire. We have the principle of defense of competition on the new constitution since 2010, but only on 2018 the government decided to enforce the principle, submitting the Competition Act and all kind of regulation to implement. And this was because we had economic problems, financial problems, and the government understand that need to change things on the way that we are governing on economics. So we think that it's replay of the time and the strength of our work, and maybe we can change the minds, even the politicals. Another thing is, if we became independent, we deal directly with the National Assembly. So all our work will syndicated for administrative purposes to the National Assembly and the other to the court. So we think that could be easier to talk and to change the mindset.
Yeah, no, thanks. George, good to see you after a long time. Good. I didn't recognize you in the yellow mask until you spoke, so yeah, good to see you after a long time. Look, from our perspective, I think the bottom line is, what is the objective of the COMESA competition regulation? I think we are driven by that, and I have my own variant of the US Declaration of Independence penned by Thomas Jefferson in 1776, I think, if I recall my history, where it says, we hold these truths to be self-evident, that all men are created equal and they are endowed by their creator with certain and unalienable rights. That's the right to liberty, the right to life, and the right to a pursuit of happiness. I have my own variant to competition law on that all frames and undertakings are created equal, and they are endowed with those inalienable rights in terms of their right to exist in a distorted market, in free and liberalized markets. That is my variant of the US Declaration of Independence. And if you look at that as the objective, really, as long as you are doing everything and anything within the confines of the law, pursuing that objective, that undertaking should be free to engage in a market that is not riddled with anti-competitive conduct, I think is good enough for us. The amendments that we seek are simply to make this system much more effective and more efficient. Not that what we have currently cannot work. And as Mburu says, if if COMESA Competition Commission in 2013 sat down and listened to all these criticisms of how it can't work, how the law is bad, there would be no COMESA today. But I think people who were there then were bold enough to say, this is the law today, and we implement it as it is. So I think that would be my position to your comment, George.
Thank you, everyone. This then brings this.
But Tolani, before we come to an end, there's a question. There's a question or a matter that I think would be very important to address here for both the lawyers and your clients. And I think this is the issue of Egypt, Tunisia, and Ethiopia. I don't know how you forgot about that. But you see, Tolani has been troubling me. What is the status of the Ethiopia, Egypt, and Tunisia? Because we have been asked to notify in Egypt, we have been asked to notify in Ethiopia, we have been asked to notify in, which is the other country? Tunisia.
Yeah.
So I think I thought I should clarify on that quickly on those three countries. The first one would be Ethiopia. To the best of our knowledge, there is no double notification in Ethiopia. And I say this because, one, look, we've had 3 CEOs of the Trade Competition and Consumer Protection Authority of Ethiopia, 3 CEOs who sat on our board. And every time we've raised this question to them that we are receiving these questions from lawyers, they've said that does not exist. In fact, one of them got so annoyed and said, this is the last time it was in a board meeting. Said, this is the last time I'm answering that question because now I'm fed up with you guys telling us that thing does not exist. And then look, Derek and I were privileged to be in Ethiopia at one point on a case involving Coca-Cola, if I recall. And one of the issues that arose in the Ethiopian tribunal then was what is the status of the regulations in COMESA? I think the Ethiopian adjudicative bench then had said, even if there was COMESA, transactions needed to be notified in Ethiopia. But when that was appealed to the tribunal, appellate tribunal in Ethiopia, that issue was overturned, and the tribunal was very clear that once notifications are made at COMESA, you don't need to notify in Ethiopia. And I think that's the position, Derek, in as far as I remember. And I was very clever this time to bring one of my officers who recently joined us from the Ethiopian Competition Authority. I brought him here so that when I speak, he's there, you look at him and you'll be able to attest that I'm not lying, because then I'll be lying. So he's there, I'm sure he understands it. So I think it's a matter of, number one, maybe dealing with new staff there who may not understand exactly what is happening, dealing with local counsel who also may not appreciate what is happening. And we've always asked lawyers, if you have an issue like that, please bring it to us, then we table it with the Ethiopians. And none has done that. Egypt, I think there's been a confusion, because Egypt has also been telling us exactly the same thing, that look, once a major is not, in fact, they've brought majors to us. There's a case on Uber. Egypt brought it to us, actually. So they've said once a transaction is notified at COMESA, there is no major notification in the context of reviewing that major and issuing a decision in Egypt. The notification that is there is what I may probably compare to what is happening in Kenya. Because in Kenya, even if the notification comes to COMESA and COMESA will review that if it has regional dimension, you still need to inform the authority there, if I'm not mistaken, Raphael, that there's this transaction that is taking place. It's not notification in terms of review. It's exactly the same situation in Egypt, and the Egyptians have been very clear to us on that over and over and over. Tunisia is slightly different situation. Tunisia only joined COMESA, I think, in about 2019, if I'm not mistaken. Then later on, there were all these COVID issues. So governments, sometimes when they enter into these agreements, it's not automatic that immediately everyone down there understand what is happening. So I went to Tunisia in November last year. I was there and I realized they had no clue of what was happening. And in fact, there was even some other confusion in that in Tunisia, the Minister of Trade actually is responsible for competition matters and also majors, but they also have a separate competition authority that also reviews majors and other. So even within Tunisia, there was that confusion. So when you added the COMESA layer, they were even more confused. But that doesn't mean that something won't happen. Tunisia joined the COMESA recently. There's a lot of work that needs to be done in Tunisia itself for them to understand all those issues. But Egypt, Ethiopia, the story is settled. Tunisia, it's a matter of informing them exactly the obligations under the treaty, which they did not understand. So I thought I should make that very clear.
No,
thank you.
Thank you. Really appreciate it. And thank you everyone for all your time and listening to us.
This is panel 2. We're going to be talking about competition policy and trade imperatives in Africa, inevitable tensions, and our speakers are going to give us some diverse perspectives on that. I think all of us agreed in our prep for this panel that the most taxing aspect has been dusting off our suits and trying to find our high heel shoes. I think many people in the audience look like they may have had the same problem, but thanks for joining us. It's great to see all of you. And as X said in his address this morning, really wonderful to see everybody in person, and we're so happy we can do this again. The African Continental Free Trade Agreement will create an economic bloc of about 1.3 billion people, which will be the world's largest trade zone. Preferential trading agreements between the member countries will need to be unbundled to allow for wider cross-border trading, creating a wide range of much more competitive African markets and enormous flows of imports and exports. However, the potential tension between these trade imperatives and competition enforcement has been highlighted in South Africa recently, in particular since the formulation of our various sector plans and the policy statement on competition for policy for jobs and industrial development, which was published by the Minister for Trade, Industry and Competition last year. In that document, Minister Patel identifies the important role played by the Competition Act and what he calls policymakers, I think he means the Competition Commission, in promoting greater localization as a means to increase industrialization and increase development of the South African economy in a more inclusive, transformed, and vibrant way. The Competition Commission has taken on board this imperative and is already starting to ask merged firms what they can do to contribute to localization in the context of merger reviews. In addition, the Commission has released a draft guideline which help assist South African companies to understand how they can collaborate in ways that support localization, for example, by setting targets for increased local procurement. At the same time, we've seen an increased use of protective trade measures, including safeguard duties, which have been applied to shield local South African businesses, including in areas of the economy where we've seen former monopolies engage in excessive pricing, like steel. New restrictions in the Competition Act, which have yet to come into force, will inhibit the ability of foreign investors to compete to invest in South African markets. So this is what our panel today is going to be discussing from their unique perspectives. I'd like to welcome our panel and thank them for joining us, especially those of you who gave me a heart attack because I thought you might not pitch up. First, I'd like to welcome Baki Majenje. He's the Legal Services Division Manager and Acting Deputy Commissioner of the South African Competition Commission. Next to him is Tatenda Zageli, Senior Researcher at the Zimbabwe Competition and Tariff Commission. Then we have Phil Alves from Berkeley Research Group. He's an economist in their team there. And my partner, Lebogang Mapidikani at Bowman's in the Johannesburg office. And last but not least, Mr. Thomas Janssens from Freshfields, who gave us a heart attack about his not being here, but has luckily managed to come in just exactly on time. You're most welcome, Thomas. Baki, if I can ask you to kick off, would you like to give us some perspectives from the South African Competition Commission to things like localization, perhaps in merger control, and also speak a little bit about your draft guidelines?
Thank you, Heather. Morning to everyone. I must first start with a disclaimer, Heather, that I will not be speaking on behalf of the Commission unless the context indicates otherwise. Let me perhaps start with two observations. The first observation is that localization essentially is an industrial policy instrument that lies within the domain of policymakers and not necessarily competition regulators. The second observation is that the concept of localization is quite a broad concept, which is amenable to different interpretations. And where the objectives of localization intersect or overlap with some of the public interest provisions of the Act, then in that sense, then it could be said that the public interest grounds in the Competition Act promote localization. But that is not necessarily the primary objective, because the primary objective of the public interest provisions of the Competition Act is to secure the public interests which are recognized in the Act. For instance, localization intersects or overlaps directly with the public interest objective relating to impact on industrial sector or region. So where a merger has such an impact, interventions to address that impact and to ameliorate that impact and to craft remedies to address that impact may then intersect or overlap with localization. But I would suggest that the primary objective of this public interest objectives of the Competition Act is not necessarily to promote localization, because that is not expressly referenced in the Act. And of course, the supplier development funds, which have been imposed within the context of merger control, if one looks at them, they are essentially aimed at creating or unlocking value chain opportunities for smaller suppliers, or promoting entry by smaller suppliers. So one can then see that such an outcome then dovetails with the objectives of localization in that sense. In fact, interestingly, the Masmat Fund, which was really the first of its kind within the context of merger control, actually set the trend for other measures that followed afterwards in terms of crafting supplier development funds within the context of merger control. And I must say that this was not, as we all know, at the initiative of the Competition Commission, but this was ultimately an initiative that ended up being secured through the Competition Appeal Court. And I see that the Judge President is here. And in fact, we have done a study of the impact of that fund. And we found that it has created significant opportunities for smaller suppliers. Maybe let me pause here, Heather, then we can return to the issue of the guidelines in order to give my colleagues an opportunity to also speak on the issue. Thank you.
Yeah, thanks, Vake. So if I understand what you're saying the Commission is about making opportunities, and this can sometimes be applied through merger control, not necessarily in the business of requiring that firms switch away from imports, although that may be a consequence of fostering local markets. Is that right?
Yes, I think I have to make the point very clear that one of the important public interest grounds that the Commission has to engage with is as we all know, the impact of a merger on an industrial sector or region. So where that impact is apparent or indicated, and there's a need for an intervention, that intervention may take the form of a remedy to promote, for instance, local farmers, suppliers, local value chains. So that kind of a remedy, although it looks like localization, it's not necessarily localization, but it's primarily aimed at addressing the public interest, the public interest issues that may arise from a transaction. So it's really an issue, as I see it, of overlap and intersection, or even one could even venture to suggest coincidence, but the objectives may be the same as localization objectives.
And not necessarily the same as the kind of policy instruments that state buyers would apply, for example, where they say we will not buy a particular product unless it has a minimum local content.
Yes, it's not a full or a hardcore, these are not full hardcore industrial policy interventions, because that lies within the domain of government or policymakers. And to use major control in a way that is geared towards promoting industrial policy, major control may not necessarily be the appropriate instrument for that. But the objectives, the public interest objectives may coincide with the objectives of localization. So I think, yes, I think it's really an issue of labeling, as I see it, because it's very easy to label these major remedies as localization, but that is just a label, because if you look at the real substance of the interventions, these are public interest interventions.
And then, as I understand the Commission's draft guidelines on collaboration, those do anticipate that local competitors might want to get together and agree on targets. For example, we will purchase 50% of a particular input locally in South Africa rather than importing it, or we will decrease our imports over time. Presumably that guideline is meant to facilitate that kind of conduct.
Yes, in terms of the guidelines that the Commission has been issuing in terms of Section 78 of the Competition Act, those guidelines are not aimed at regulating localization, because the Commission is not the regulator of localization. Those guidelines are aimed at creating a framework for ensuring that policymakers or the private sector, should they wish to engage in localization initiative, they should do that in a manner that does not give rise to coordination or to cartelization. So that is really the primary objectives of the guidelines, to ensure that localization is done in a manner that does not hurt the Competition Act. So that's really the primary objectives of those guidelines. And you can even see from the guidelines themselves that in the manner in which they have been crafted, we do envisage that these initiatives will have an exit point. They are meant at addressing a particular problem, and at some point there will be localization will be exited. I think a case in point is the guidelines that we published in relation to the sugar cane industry. It is very clear that the guidelines are responding to a master plan, a 3-year master plan. Then after that, according to the master plan, localization will be exited, because the intention is to respond to the current challenges facing the South African sugar industry, which we all know. And part of the objectives of localization as we understand it, hence we are sympathetic, but not necessarily primary sponsors of it, is that it has linkages to a number of other objectives, including, for instance, job preservation, as well as job creation. Thank you, Heather.
Thanks, Vake. Tatenda, moving on to you, would you like to give us some perspective from Zimbabwe, similar sorts of measures being put in place?
Okay, thank you very much, Ida, and good morning to everyone. I think from the Zimbabwean side, let me start by, maybe I have to highlight this in the beginning so that I think it's actually important in terms of the context of our discussion. So in Zimbabwe, what we have is we have got a combination of the Competition Commission and the Trade Tariff Commission. So our institution is called Competition and Tariff Commission. So we have got a mandate to promote and maintain competition. And we also have a mandate to ensure that the local industry is very competitive in terms of offering assistance to local industry. That is through basically tariff review, where you reduce tariffs on raw materials to allow the industry to become competitive, and also review tariffs upwards in order to, I didn't want to use the word protect, but to protect your local industry. So we have got that kind of unique institution. I think I've researched around it. I think it's only us who have got that kind of unique institution. Now looking at localization, I think I must be very clear here to say, in Zimbabwe, what we have observed prior to COVID and even during the pandemic is the rise in this lobbying about localization. We need to buy local and so forth. And that actually created an organization called Buy Zimbabwe, which has lobbied with government to come up with a local procurement policy, which is now in force. However, we don't have those kind of regulations that force us in our law, in the competition law itself, to say when you're approving a merger or when you're dealing with a restrictive practice case, you have to look at issues to do with localization. We don't have that in our act, but we have got sort of a flexible public interests law that we, in Zimbabwe, it's not a prescribed, it's not defined in our law to say public interest is such. It's not prescribed. So what we have done in the past and what we continue to do now is, in a number of cases, we have approved measures conditionally. I will give like an example. I think most of you are aware of the Coca-Cola Schweppes measure. In Zimbabwe, it was approved conditionally. And some of the conditions there, one was to say Coca-Cola, apparently Schweppes in Zimbabwe had a brand called Mazoe. I think some of you are very familiar with that good taste of cordial. Yeah. So they were Schweppes in Zimbabwe was producing Mazoe. Then there's another brand called Calypso. So when that measure was approved, there was a condition that Coca-Cola must maintain those brands and they must be registered in Zimbabwe, and they must also make those brands regional, and which is something we did an impact assessment in 2019. And when we were meeting with Schweppes in Zimbabwe, they were actually telling us that Mazoe is now regional. They are selling Mazoe all over Africa. So it's something that came out of the public interest issues. Another example again is on AB InBev and SABMiller. Apparently in Zim, SABMiller controls a company called Delta. So they were also producing a local brand for beer lovers. It's called Bollinger's and Zambezi. And we also applied similar conditions to say you must continue producing these two brands and also make them regional and international. So we have got this kind of public interests where we can actually navigate our way through localization. And I think if you were listening to what our presidents were saying last week, they were talking about the need for us to produce our own vaccines and things like that. So this is an issue that is coming from heads of state. And it's something now that while we don't have something in the act that says, you must do A, B, C, D, and E. So we try by all means to factor that into into our analysis and into the work that we do on promoting and maintaining competition. Maybe I will also speak about the unique setup that I spoke about. So what you have now, remember I said you have a competition commission and you have got a trade tariff function. So there is an application for a company applies for duty review upwards protection. It applies and say, want protection, we are facing stiff competition, blah, blah, blah. The moment they say stiff competition, we also have competition people who are sitting there. So we have got that kind of internal kind of regulation within the commission. And that results in what I would call an optimal kind of enforcement of competition law in Zimbabwe. I think that is what I can say for now.
Fantastic. Thanks very much. And before we get to the rest of the panel, I'm going to take any questions. Does anyone have any questions or comments at this point? Yes, go ahead.
Dana did mention Schweppes Coca-Cola merger, and I just wanted to say I played a prominent role in that merger, and I was involved in the AB and InBev merger. But the important point I want to bring home, apart from bragging about what I did, is to say that the attitude of the Competition Commission has always been to say we will advance the interests of the economy over and above sectorial interests. And that has always, all the dealings that I've had with them, that's always been the driving force. What is this going to benefit the economy? How is this going to benefit the consumer? So I think they still maintain the same attitude, and it's really a commendable one.
Question or comment? Okay, great. Phil, let's turn to you. Any thoughts from an economic perspective?
Thank you very much, Heather, and thank you for inviting me on the panel. Good morning, good afternoon. What time is it now? Good morning. Good morning to you all. Where to start? It's a huge field. I'm excited to be talking about it. I used to do trade policy work before I turned to competition and regulatory economics work. My career has kind of followed the trends in development policy, kind of unwittingly, not on purpose. But I joined the Competition Commission as the global financial crisis hit. And the global financial crisis basically ended the supremacy of thinking in development economics, or at least orthodox thinking in development economics, about the primacy of trade liberalization as your kind of spearhead for driving economic development. So this is a very interesting topic for me. I guess 2 or 3 broad. I mean, it seems to me that recent industrial policy discussions around localization under this new master plan framework, and even more broadly, it's been described as a reimagined industrial policy for South Africa. I suppose that's in reference to the industrial policy efforts that were made or kind of emerged in the aftermath of the global financial crisis and were implemented until about 2018, 2019, when this conversation started about reimagining industrial policy. But I think for me, the first observation is that, I mean, localization, the word is new in the debate, and some of the methods that localization, or some of the methods being promoted in order to promote localization, I guess are new as well. So encouraging more domestic procurement. Government, I think government said no to ever using imported cement, or something along those lines. That's kind of new, but the shift after the global financial crisis has basically been towards increased trade protection and increased intervention in the economy through various industrial policy tools, trade policy being a big one, and that is all a drive to localize. So what we seem to be adding now is as I said, new, different, additional tools, I guess, to try and accelerate the localization process. The other, I guess, big observation is that this feels pretty old-fashioned. This feels like pretty old-fashioned import substitution. So we've seen on the trade front, we've seen anti-dumping duties being used much more intensively and extensively. We've seen increases in most favored nation tariffs under our WTO commitments. We've seen subsidy programs since the re-emergence of industrial policy around 2009 and 10. And we now seem to be, as I said, accelerating that thinking with more explicit and direct measures to protect domestic producers in various sectors. And I guess the high level observation has to be that the impacts or risks of this particular policy approach surely lie in potential price increases, inflationary pressure. Many people have observed that, and do seem, on the face of it, and I can't claim to have spent many hours thinking about it in detail, to work against the sort of basic and core objectives of competition policy and competition law as we've understood it. Public interest concerns, setting them aside for now. But, competition law enforcement has been about preventing mergers or blocking mergers that might increase prices, discovering cartels and preventing, ongoing effects on prices from price fixing agreements, preventing dominant firms from raising prices through various different abuses of their dominant market position. I mean, there seems to be an obvious and very clear tension between that broad objective and a sort of renewed or accelerated commitment to trade protection, sort of defined very broadly. And then the other obvious tension for me is, we have commitments to the WTO, but also to different regional integration arrangements or regional trade agreements, the latest being the Continental FTA. I mean, I think that localization and various other industrial policy tools are also creating some obvious tensions with the objectives that those other processes have been trying to achieve and have said they want to achieve going forward. So I'll just leave it there for now. Thanks.
Thanks, Will. And then we thought, going into this African continental free trade world, it might be interesting to hear from you, Thomas. How are these tensions being balanced out in the European context? And do you see the same tensions at work?
Thank you, Heather. Is this working? Yeah, it's working. Yeah, good morning, everybody. Also very happy to be here in person again. I also, before starting, would like to echo what Judge Davis said about Rob Lee. Really, I'm ever grateful for having known Rob for what he did in terms of the collaboration between our firms, Freshfields and Bowmans, and also just for having him as a friend. Turning to the topic today, it's actually a great coincidence that this week saw the first EU-Africa Competition Summit. And that clearly will build a platform for collaboration on all sorts of issues and exchange of ideas. So that I can only encourage that, because that's something that I really support very much. The topic, indeed, you see globally this tension between regional integration and protectionism. And in Europe, that's in a way a tension between the integration of the single market on the one hand, and then national interests that continue. So I'll briefly speak about maybe first of all how EU competition law is a tool, has been a tool for regional integration. Then I'll speak about some of the trends towards protectionism that we see in Europe, and then I'll speak finally about some initiatives where Europe as a whole is acting in a way against the rest of the world. So first of all, on the first slide, I don't know whether somebody can turn the slide, but it's not essential. On the EU competition law, maybe a few words on the one hand on state aid and on the other hand on merger control. If you imagine 27 member states in Europe, which form in a way a single market where goods, services, capital and persons really move freely. That's how it operates, at least on paper. But you also have national interest, and you have actually 27 member states which have a varying degree of economic development. Some of them are former communist states where they had state-guided economies. So obviously the notion of state subsidies historically has played a very important role there. Now in Europe we have this quite unique system of state aid control. Essentially, state subsidies need to be approved by the European Commission, either individually or through block exemptions. They need to be notified before being implemented, and the state aid rules are directly applicable in all the member states. There's essentially no other jurisdiction that has rules like that to such an extent. The US does not have this, other confederations don't have it, and it goes beyond, for example, what you have at WTO level, because WTO of course also has its anti-subsidy rules, but those are focused on goods. They're focused on specific types of subsidies. They don't have this pre-authorization. It's really only when there's a complaint from another country. And the remedies also in WTO are prospective, whereas in the EU, if state aid is found to be granted illegally, there's an obligation to the member state to recover the aid, so to get the money back. So that's state aid, and I'll come back to how that plays nowadays. On the other hand, you have merger control. We have a one-stop shop, as you know, at EU level for transactions that meet certain thresholds. That is based, the EU merger review is based on competition law criteria. We have the same debate ongoing and going back to the first panel of today as to what actually is covered by those competition law criteria and whether aspects like protecting the environment, protecting employment, etc. can also be part of that. But that's an ongoing debate, and I won't go further into that. But you have a tension also between, EU merger control and member states protecting their their national interests. Essentially, the EU merger regulation prohibits member states from interfering with the EU review and with mergers that are cleared by European Commission, except on some very, very specific grounds, grounds that relate to public security, plurality of media, and prudential rules. But that is something which, well, regularly pops up, and it's fair to say that nowadays there's more and more tension there as well. And for example, recently, the European Commission started proceedings against Hungary because the European Commission had approved a merger in the insurance industry, which also affected Hungary. And Hungary actually introduced a law which it labeled as a foreign direct investment law, and prohibited the merger locally on that basis. So there you have a clash. And that takes me to the next slide, which shows some of the competing interests which you see nowadays. The tension between integration and localization, if you want, within the EU. And this has been a seesaw, or maybe even a roller coaster in terms of trends towards more integration and trends towards national interests and some protectionism by individual EU member states. So first of all, on EU state aid, for example, it's pretty common ground that state subsidies, state giving money to certain activities, to certain companies, that is called by the prohibitional state aids in Europe, except for the exceptions, as I mentioned. But member states have gotten smarter, and they've wanted to promote their local industries. And for example, they've introduced tax schemes to attract big tech companies. And cases involving Apple and Amazon were brought by the European Commission, telling off member states, for example, in the case of Apple Ireland, for actually having sort of covered kind of state aid measures through essentially favorable tax regimes. Now, in that particular case, actually, this was challenged before the European Court, and the European Court actually concluded that this did not, or that the European Commission at least did not show sufficiently how this was a specific tax, specific state aid that would favor Apple. So that's a tension which you see there. A second one is, for example, in merger control, where a number of mergers in Europe may be driven by the threat from competition, say from China. A good example there was the merger between Siemens and Alstom, two companies that manufacture trains. And one of their key arguments was, look, we need to do this because we need to build a European industry because the Chinese are coming and the Chinese are going to take over. And the European Commission actually didn't buy that. They said, no, this is going to limit competition, and we don't see the Chinese there yet. This is way too far into the future. And so the mere fact of creating a European champion is not sufficient to approve your merger. Now that created a whole political upheaval. And actually the ministries or the finance ministers in France and Germany actually published a manifesto urging the European Commission, and they were then later on followed by other member states like Italy and Poland as well, urging them to actually not be so naive about this issue and to amend EU merger rules to account for this kind of threat from outside of Europe, so in a way protecting Europe. Now, again, the European Commission itself rejected that, at least under the competition rules, and I'll come on to some of the initiatives outside of competition law that this has generated. Finally, I should say, okay, European champions, that's one thing, but a number of member states also try to promote still national champions. They try to promote mergers between, for example, national energy companies, telecom companies, transport companies, to in a way make them stronger against threat from even competition in other member states. And again, that is something which the European Commission has consistently really rejected as a driver for those mergers. So those are some of the competing interests which you see at the moment, where on the one hand, member states try to look after their own interests, the local economies. I mean, at the end of the day, these are local governments which need to be elected and need to support locally. And it's easier to blame Europe in many cases than it is to actually sort of stand behind European integration, except where it is sort of to form a front against threats from the outside. And that takes me to my third and final slide briefly. First of all, there's the area of foreign direct investment, where member states, again, on the one hand, protect their national interests against investment from outside of Europe. This is not the same one-stop shop as we have in merger control, but we have by now 18 EU member states that have introduced some form of foreign direct investment control. And the European Commission does play sort of a coordination role. So there is a tendency towards more integration there as well. But as I said before on the example of the Hungarian blockage of the insurance merger, you have some tension there, which you will see also in the future between sort of EU interests and national interests. So that's foreign direct investment. Secondly, and in response to everything coming out from, in particular, the Siemens Alstom case and sort of the political backlash which it's generated, is a proposed new instrument on foreign subsidy control. So this is essentially, in very simplified terms, applying the logic of EU state aid rules, but to state support from to companies that are based outside of Europe and come and do business in Europe, come and acquire companies, come and compete with European companies, come and participate in public procurement. And they're essentially, for example, for mergers, this proposed tool would require an additional notification of, say, if a Chinese controlled company, which may benefit from state support, but also, for example, a sovereign wealth fund from the Middle East coming and acquiring a European company, there would be a check and a review as to whether this, in a way, would distort competition within the European market. So that's an important development. I couldn't talk about this topic without briefly saying something about Brexit, of course. And where I said sometimes it's sort of the European member states joined up against the rest of the world. Now there is an additional sort of outsider, which is the UK, of course. And clearly Brexit has, in a way, generated quite a lot of energy among the remaining member states in terms of pulling together. The UK is now a third country. There is a trade and cooperation agreement in place. But for example, the EU has already indicated, and EU member states, a lot of concern about the much less strict framework for state subsidy control, which the UK is looking at. Now, interestingly, for these purposes, for the foreign subsidies tool, the UK would also be a third country. So that's in a nutshell sort of some illustration how this sort of this seesaw you see between integration on the one hand and localization or protectionism on the other hand, also in Europe.
Very interesting. Thank you, Thomas. We're going to pause there and see if anybody's got any comments or questions.
So my question is to both Bake and Thomas, and I wanted to ask, just in relation to foreign direct investment and ministerial intervention in mergers, to Bake, where are we seeing that going with the new amendments giving the minister sort of greater powers in direct engagement with the merger process, along with the commission? My understanding is previously, parties would have separate discussions with the minister, and, he would intervene in the tribunal process, and ultimately conditions would be extracted. So I wanted to know if there are current, synergies between the minister's, involvement as well as the commission, and Thomas, how that process also works from a European perspective, especially where there are different member states involved in different political sort of involvement.
Yeah, in terms of the ministerial role in merger control, we know that the Act demarcates the role of the minister to public interest issues and to engage with public interest issues. I don't think there's anything wrong in that legislative policy approach, especially when one is dealing with public interest, because obviously the minister is best placed to engage with some of the questions arising from public interest issues. Of course, that doesn't, of course, deauthorize the commission as well as the tribunal from engaging with those issues. But I think the safeguard, I would say, in the process is ultimately the oversight role that the tribunal plays in the process. So I think the demarcation has been crafted quite carefully in the Act. There is certainly a role, in my view, for the involvement of the policymakers in public interest issues generated by major transactions.
Thomas, in Europe, I think the question was, how is this all juggled?
Yeah, exactly. And the reality is that they are sort of separate processes, and it makes actually sort of getting all the necessary approvals for major transactions very complicated. Especially because we have, and this is still in development, so you often see new regimes coming on stream in the course of a transaction, and then you sort of need to notify late in the day and try to sort of fit all of that into a timeline. So it is, as I said, at the moment, 18 member states, potentially 27 member states for foreign direct investment on the one hand, and then it's a transaction with an EU dimension, the European Commission looking at it from the merger control perspective. Now, as I said, on the foreign direct investment, you do have now a cooperation mechanism, and the European Commission tries to streamline that, but they are not the decision maker there. They are just trying to make sure that member states speak to each other, that they look at the right kind of interests to protect, and trying to avoid too much divergence as well. But it raises quite a bit of complexity, and it will be interesting to see whether over time, especially if sort of on the foreign subsidies, there is sort of a common regime, whether over time we also get a common regime, so a bit like CFIUS in the US, but then at the EU level, but we're far from there.
Thanks. There was a question.
This question's for Thomas. Going back to the foreign direct investment sort of second leg of merge analysis, so where you say you would look at whether the acquirer has been assisted by the estate and the like. I mean, currently is that looked at intra, EU, where, for example, if somehow Italy comes out of its slump and decides to go buy companies throughout the rest of Europe, would that be a problem for the EU where they would have an influence? Or is it solely because it looks at members outside of the EU? And so that's what I would like to know, if they've thought about that.
Yeah, no, it's a great question, because I mean, indeed, typically, say a company that has links to the government of a given member state, which invests in another member state, that should not set off the alarm bells in terms of national interests, because that's the idea of the common market. And on top of that, the EU treaty actually has a provision which says that sort of it's neutral as to the source of ownership, whether it's state ownership or private ownership. So that should not play a role. So it's looking more at the outside, and so it's, for example, looking at whether a Chinese company buys into, say, an electricity grid, and the question that raises in terms of the security of supply within Europe and the threats this could raise. I say within Europe, but I mean within the different member states. But it's pushed pretty far, because we now also, for example, see some of the private equity funds, for example, where at a very high level, there might be sort of a very limited investment by the Chinese, and that already triggers off when they invest, say, in certain infrastructure, quite some concerns from those member states. But it's really aimed mainly at, in a way, I mean, it's a political instrument at the end of the day. So it is about, is the company investing, is it a friend or a foe, essentially? Yeah. Yeah, no, exactly. Typically, that is not seen as sort of something of that pertains to the national security. But
only 'cause you're not a Man
actually,
City
there's
fan.
yeah, but there are some. I mean, for example, the French, when I think it was Kraft was planning to, or Unilever, I forget who it was planning to buy into Danone, yogurt producer. That was seen as sort of a national, an asset of national interest, and so essentially how it happens very often, and likewise, for example, when I mean, a number of years ago, there were talks that Pfizer would acquire AstraZeneca, a UK-based company, and the UK was up in arms, and so the political level then, in a way, starts raising noises about, oh, this is against our national interests, etc. You also saw it, by the way, in the NVIDIA ARM deal, which recently tanked, in part because there were these potential concerns. And there you can sort of see, okay, chips, that goes maybe more closely to sort of what could be strategic interests of a state. But my point is that often it is sufficient for governments to sort of raise these issues for these deals then to become de facto very, very difficult to implement and to pursue.
Thanks. Any other questions? Yes, go ahead.
Thank you. Mine is to Bake and Tatenda. Bake appears to be supporting and justifying the role of the minister in these public interest issues. And obviously, it justifies that further that there's a safeguard at the tribunal level. My question then is that, don't you think there's a risk of congesting public interest issues with political issues, if I may use that, because the minister is a political authority? And then don't you think then Judge Dennis remarks this morning that we should not be seeing public interest as this floating ghost or somewhere which is completely separated from competition assessment? So if we are giving that big role to the minister, don't we then actually completely divide that integration between public interest and competition assessment pure? And then even if there's that safeguard at the tribunal level, don't you think perception and psychological influence still, I know we'll talk about objectivity and everything, but humans are humans, and influence and psychological influence and perception is very important in these issues. So I'm not so sure those safeguards would completely eliminate the political issues finding themselves under the guise of public interest, but I'll hear more from you. And then Tatenda, the Zimbabwean major control provisions, in fact, the COMESA competition regulations, major control provisions, I copy paste of what is in Zimbabwe, Zimbabwean law, word for word. And one of the issues we've had is that issue of public interest. Because in our view, if you look at the major provisions purely, we failed to find a provision that would support public interest as it is non-traditionally, because we look at those things to be pro-competitive matters. We've over the past obviously tried to push in that, but not from the major control provisions per se, but from Article 2, which talks about public benefits or something like that. Now, I heard you said, even if it's not properly defined in your law, the Zimbabwean authority still does consider public interest. How have you navigated the interpretation of what is in your law? Because
to us at COMESA, which is a copy paste of yours, we think that is not public interest as we know public interest. And then if you are saying there's a way in which you address those things, how have you then addressed the issue of uncertainty? Because obviously the emerging parties there would want to exactly know what you're taking into account as public interest. Thank you.
Marky?
Yeah, thank you, Heather. In fact, it looks like that risk is more heightened in the European Union rather than here. But I think the role of the minister is clearly defined and clearly circumscribed in the Act. And we must remember that in terms of the old Maintenance and Promotion of Competition Act, actually major control was a ministerial role. So with agentification, this role, of course, was then given to the Commission. Of course, there was the old competition board, but effectively this was a ministerial role. So that shows, in my view, that when one looks at the legislative evolution, South Africa has always assigned some form of a ministerial role in major control. So of course that role has now evolved under the new institution. Because the alternative is that if you don't concede some form of ministerial role, especially when it comes to public interest issues, that then you may even lose you may even have the worst case scenario where you lose the agencies and the politicians claim the entire space because there's no accommodation of the executive in the process. So those are some of the pros and cons, I think, that have to be weighed in the debate. But I think under the current Competition Act, the role has significantly improved than it was before. But completely, I think, ousting the ministerial role may have unintended consequences, because if those interests are not accommodated in the process, then that may also create other unintended consequences.
Okay, thank you very much for that question. I think I have to agree with you to say the COMESA regulations are almost similar to the Zimbabwean competition law. On the issue of navigating, maybe let me start by highlighting, I think it's something that you have asked to say, there is always a political kind of interference that comes when we don't prescribe on what we mean by public relations. So by public interest, I mean. So in Zimbabwe, in terms of the institutional structure, which is something again which we are working on. By the way, I should have said that we are actually in the process of amending our Competition Act to try and make it more effective, include things like penalties, which is actually not in our act. We have got commissioners, basically who are political appointees, if you want to put it that way. They are political appointees, and they have the final say. In Zimbabwe, the institutional structure, we don't have a tribunal. So we have got the commissioners that make the final decision. And when you want to appeal, you go to administrative court. So it's something, again, that we are trying to work around in the amendment. So when you have that kind of a scenario, my duty as a case officer is basically to investigate and offer some recommendations. Then you have a commissioner there. We have got some kind of political interests and also to offer policy advice. Let me give you a very good example. I spoke about an impact assessment study that was done by the Commission. One of the findings there from that study was actually that on some of the measures that were approved by the Commission, they actually led to a decrease in exports. How did that happen? So you had that kind of multinational company policy overriding your national policy. So you have a company that is acquired in Zimbabwe, and that company was exporting to Mozambique. Then you hear now you are not able, you are not allowed to export to Mozambique. There is another country that has got secured that market. So you are no longer allowed to export into Mozambique. So that actually led to what? A decrease in exports in some cases. So you present that report to your commissioners and they are reading that. What are they going to say now? Obviously, they're going to say, I think, you know what, when we are going to approve measures next time, we also need to look at issues to do with exports. Plus another point that I made, that we have a trade tariff function again in our act. So you also have those guys from the trade tariff investigation side say, you know what, this measure can actually result in what? In a reduction in our exports. Yet we are actually trying to increase our exports. So it's not easy. But I think we are currently benefiting from the institutional structure that we have at the moment. That is point number one. Point number two, I would say in the past, we haven't received a lot of court cases around our decisions. But this has now started to change. I think from last year, I would actually say, I think there is our lawyers are actually rising from slumber. Because, you know, for I think when in the introduction, there were some remarks that were made around fines that we have imposed as a commission. We have faced a lot of court cases challenging those decisions. And what is also disappointing is something that I think you, Willard, has mentioned, to say these lawyers now focus on technicalities. You know, it's very easy for you know, mistakes are very common. It's very easy for you to make a mistake. So they just say, you know, you didn't do this, and you know, everything then falls down. So that is another point that is making us maybe happy at the moment, but we are also trying to change that now with the new amendments that we are working on at the moment.
So Tendo, I think your point about the risks of applying these kinds of conditions in mergers or driving the policy is potentially unintended consequences. And that this is not a strategy which is entirely without difficulty and needs to be carefully balanced. Lebogang, you sat on the inside of the Competition Commission and now sit on our side, assisting clients trying to do deals. What are your thoughts?
Yeah, thanks, Heather. So I think I'll focus more on the, the barriers to increasing or stimulating localization, or the threats even, right, to localization. And I'm going to start with the most obvious one, which a lot of the panel members have touched on, which is the obvious threat of litigation, particularly in the South African context after the amendments to the Competition Act. And I'll explain a little bit how, this threat sort of plays itself out during the merger assessment process and in the context of the public interest assessment, because I think that's where the theme of localization sort of finds itself in the entire merger regulation framework. Let me start by saying I heard Bake very well saying the Competition Commission's objective is not localization, but some of us sitting on the other fence, you read these conditions that are flowing from the Commission, and when you look at the substance, Bake, I am sorry to announce, it is localization, right? Yeah, maybe it's semantics, but that's really how it reads, and there's obviously like a clear overlap here and there. I think at least you've admitted to that. So I think the first thing to point out really is that every time you look at a condition imposed during a merger in South Africa, and it looks like a localization condition, it's usually in the context of the commission dealing with one of the pillars of public interest, which is to assess what the impact of a merger is on a particular industrial sector or industry, right? Industrial sector or region, rather. And I think it's almost obvious why that is the case, right? Now, the issue of litigation being a threat really comes back way back, because one gets the sense that in an effort to sort of stimulate localization, competition regulators in particular are beginning to veer away more and more from traditionally established international competition law principles. A case in point, in fact, I suppose the easiest example to make is the example around the principle of merger specificity, right? For those of you who don't know, I mean, when we talk about merger specificity, we're basically talking about an inquiry that a competition regulator embarks on in checking whether what the impact of a particular merger is on public interest or on any of the pillars of public interest. Now, you see, and I think when I emphasize that these are long-standing, internationally recognized principles of competition law, which in fact were recognized in South Africa until what we're seeing now recently, which seems to be a little bit of a shift, because after the amendments, there seems to be an interpretation that you can't have a public interest neutral transaction in South Africa. In other words, our impression, at least, is that the competition authorities are saying the act must be read to suggest that where the merger does not have a negative impact on public interest, it must surely have a positive impact, right? And which is obviously, it clashes with the idea of merger specificity, because the principle of merger specificity basically says that if the merger has got a direct negative impact on public interest, then you ought to then, as a regulator, seek remedies which are going to address those that adverse impact. But what we're seeing more and more, and again, you know, we've got some of the list of cases that we've seen here where the transaction does not have a negative impact on public interest, but there is a call from the commission or the minister exercising his rights of participation for parties to accept a condition on localization, because the parties must make a world a better place, right? Now, the reason I'm saying the risk is a litigation risk is simply because the amendments are not yet tested. We don't really have a lot of a body of work, right, to make sure that this is a correct interpretation that we're seeing, or maybe, you know, the practitioners are wrong. But the reality is that for as long as we're in this bit of a murky scenario where everybody's adopting whatever interpretation they believe is correct, then your risk of litigation is heightened, because it's only going to take one set of facts, one transaction where the parties have the appetite to litigate, and they will take it all the way to the higher courts where we can actually get the score settled, so to speak, regarding the interpretation of the correct interpretation. So that's the first risk, Heather. And then the second risk, and I think a lot of people have touched on these issues, the second risk is the risk of unintended consequences. Now, before I even go into that, I'm quite impressed by the Zimbabweans, because I think they've got something right going on there, right? Because you can't ignore, so whether or not we call it localization, or rather we say the localization drive emanates from some sort of competition framework or policy, whether or not we are ready to accept that, right? The reality is that the two are intertwined, hence the conflict or the tension, right? So I mean, in my mind, having looked at the work of the commission over the years in South Africa, and having seen some of the trade regulations, it's clear to me that there isn't enough collaboration between competition authorities and the trade regulators. And this has played itself out in the past. If you look at the Commission's intervention in the scrap metal industry a few years ago, and ITEC's regulation of tariffs. I mean, we all know that, you know, that intervention caused an outcry in the national industry. So you would think that if things were going as well as they were supposed to, then, you know, there wouldn't be such a reaction. There wouldn't be an outcry. So something is definitely amiss, and maybe we need to go back and look at how we are implementing these systems. And then, but more recently, we're seeing this unintended consequence theme raising itself again during the merger assessment process. And if I can use maybe a case study to elaborate, to sort of speak to this point, Heather. So we have a client in the retail sector, and they engaged in a few transactions, I think most of which last year and the previous year. And in one of the transactions, the commission imposed a localization condition, right? Mind you, there wasn't a credible theory of harm, which was shown on the facts that the transaction would have a negative impact on localization or a particular industry, or there was nothing like that. It almost became like a bargaining, a thing where we knew that from a competition perspective, the case was a bit of a complicated case. So I think what happens generally with business is that when the transaction is complex from a competition perspective, business is more willing to accept some sort of conditions, with public interest in order to try and push the transaction through. But my last reading of the Act says, the question is whether the transaction can be justified, right, on public interest grounds. That's my last reading of the Act, and you'll correct me if I'm wrong, Heather. So the word justification suggests that there's something wrong with the transaction from a competition perspective, and therefore you ought to then go into a public interest assessment, which would hopefully help you justify your very bad competition case in your transaction. But I mean, that's a very loaded debate on its own. So coming back to the unintended consequences and the case study, so our client is in retail, and they had a transaction, and for the reasons I've just explained, they accepted a condition on localization, and the condition was that they would increase their local spend by 50% over the next 5 years, essentially. And that was done and dusted. The transaction was approved on that basis. And then fast forward, the same client comes back. They want to acquire a store. They call them specialist baby stores, right? So your baby cities and those types of stores, your Toys R Us type of stores where there's just a specialist focus on baby products. Now, most of you would know that there's obviously an overlap in the activities of a baby store and a general retailer, right? If you walk into a Pick n Pay, for example, you're going to find mealie meal and rice and other groceries, and then on the other hand, you're going to find milk formula and nappies. So there's obviously an overlap in the activities of a specialized baby store versus a general retailer. Fast forward, what happened with the commission was that, again, and I think I need to emphasize this, the baby store, the target in this instance was in financial distress as well. So this is another issue that talks in my mind to localization, right? So if assets exit because of financial distress, because you can't get an approval or a reasonable approval rather from the competition authorities, and those assets exit, then you haven't really done much for localization, in my mind at least, So there's just so many of these conflicting themes along the way. But without articulating a clear theory of harm on whether or not the baby store transaction posed a threat to localization or had a negative impact on public interest, the commission nonetheless requested the parties to agree to a condition to increase or improve localization, right? And our view was that, well, if you study the market properly, for you to drive localization, you have to have a little bit more insight into the market you're dealing with. So it's not only just limited to the facts of a particular case, but you need to understand the market. And our defense was that part of the reason the baby store went into financial distress is because there's a bit of pressure from the general retailer space, right? That's the first thing. The second thing is, in order for a baby specialist store to differentiate itself from a general retailer, you have to focus on imported products. It has to be bespoke products. It has to be certain branded products. I mean, I know I've seen, I haven't had a baby recently, but I've seen people walking around with Ferrari baby strollers and you know, car seats. And this is what this client was saying, that if I am to remain competitive as a specialist baby store, then I need to sell products like those. And interestingly, from a trade perspective, the tariffs which relate to these particular products are very nice and low. I can import these and sell these at a premium in South Africa without offending the Competition Act and without being accused of excessive pricing. Whereas the Commission, on the other hand, is saying, no, we want you to localize more. So there's a clear tension that arises from, you know, not seeing enough collaboration between the trade regulator and the competition regulator, which at the end of the day may very well end up you know, resulting in these unintended consequences where you've now basically potentially killed a baby store because you're trying to force them to source products locally when what they actually need is to import products. And I think
I'm going to stop you there.
All right.
Okay, I'm sorry, we're running out of time, but I think we'll take one more round of questions. Would anyone like to ask a question? Terry, Udi. Hello, Udi.
Thanks very much for a wonderful discussion and event. So nice to see everybody again. Just a question. You know, it's one thing to talk about localization in the context of merger conditions, because, and Bake, this is probably a question for you. When you impose public interest conditions or localization conditions in merger context, it is the merging parties that will subsidize that localization plan. Now we are at master plans, so that's just on the periphery of merger conditions. It's still the same policy issue of localization. We are now at master plans. That can have the consequence of increasing prices, not because of any collusion, which the guidelines serve to avoid, but because of lesser competition. And who's now paying the bill? Not profitable merging parties, but the end consumer, who's very cash strapped, especially now. They can't afford Ferrari prams. So my question is, Bake, are those products and the prices of those products that are covered by the master plans, are they tracked on a continuous basis? That's the first question. And secondly, will the Commission have the independence to stand up at some point and tell the Minister the consequences, which is not unintended, it is probably, well, it's not unsuspected, it is something that can very well happen. The consequences are now just too severe from an affordability end consumer perspective, because it's the end consumer that subsidizes, strictly speaking, those master plans. Thanks.
But the question about master plans, Bake, and competition tracking, I mean, I know you guys have got your essential monitoring price report, which covers food, right? Are you starting to track anything beyond that, linking into the master plan process?
Yeah, I think I've made this point very clear that the Commission is not the regulator of localization. I must repeat that point again. As Lebu was speaking, I was furiously looking for a passage in the Walmart judgment, and I finally found it. If you may indulge me, Heather, it's a very short paragraph.
Sure.
It's paragraph 98 of the Walmart judgment. It says, viewed holistically, there is merit in the argument that the Act should be read in terms of an economic perspective that extends beyond a consumer welfare approach. By virtue of an embrace of the goal of a free market and effective competition together with an incorporation of uniquely South African elements, including the need to address our exclusionary past, which need is reflected expressly in the preamble, together with Section 2 of the Act, the legislature imposed ambitious goals upon the competition authorities created in terms of the Act. Within the context of the present dispute, this ambition is further captured in Section 12A, which mandates an inquiry into substantial public interest ground. I think this provides, in my view, a complete answer to what Lebu has raised.
Only I have raised.
Yeah, so I think the other points which have been made, of course, this issue of measure specificity will always be contestable and will always have to be assessed on a case-by-case basis. But certainly, it is not, if an impression has been created that we have jettisoned the measure specificity constraint, which is a legal requirement, I think I need to dispel that. That is certainly not the case. There may, of course, be a debate between the Commission and the parties about whether or not certain concerns are measure specific, but definitely that still serves as a guiding standard for our assessment, both in relation to competition as well as in relation to public interest issues. Most of the public interest remedies that we have imposed are usually driven by concerns from stakeholders about the impact of a measure. So these are usually not imposed in a vacuum, but there is a rational basis for where the Commission imposes this. Of course, there is a process in terms of which parties negotiate with the minister and agree on a package of remedies. The Commission is not involved in those negotiations at all. And we are usually then presented with an agreement that has been reached between the minister and the parties. So insofar as the Commission is concerned, I think we have always been, I think, adopted the approach that is guided by both the Act as well as the jurisprudence. Thank you.
Thanks, Baki. Tatenda, do you want to come in there? Any comments?
Not necessarily related to this, but I just wanted to make a comment on, it relates to the discussion though. I just want to borrow from the remarks that was made by the judge in the morning, and also from what Willard shared in the discussion. I think we find ourselves as Africans in a situation whereby we are trying to develop a local industry. And at the same time, we are also trying to make sure that industry is competitive. There's competition, there's rivalry. So there is a question that arises now to say, what comes first? Is it the development of local industry and then you regulate? Or is it competition and then you develop a local industry? So that is a very, very tricky question to answer. But I want to refer to an article that I was part of my master's reading notes. That article was written by Professor Alice Amsden and Anjit Singh. I think it's an article that I would recommend, I think some of us here to read it. It is a 1994 article. The title is called Optimal Level of Competition and Dynamic Efficiency in South Korea and Japan. So I'll just give a brief summary of the article. So what they did in that article, they looked at how Japan developed around the 1950s, where there was high growth, 1950s to 1970s, and also South Korea. So there's something that is quite stunning from their finding. One of the issues that they raised was that these countries had an industrial policy which was more powerful than competition and trade policies. So what would happen now is that in Japan, for instance, there were cases where government would actually force companies to merge. And I want to refer to what Thomas shared in relation to EU, where he was talking about those train companies trying to merge. That is exactly the point that was raised, to say you want to create national champions that will be able to compete at a global level. So there were times when they actually forced companies to merge. But actually, I think in EU, it's actually a different story, which now brings me to my conclusion to say, I think there is really need to balance, to balance between competition and also industrial development. Also looking at the context to say, if you are in South Africa, what is it that we need to look at? What is it that is we are going to benefit from competition and also from industrial policy? You'll find again that they also make this finding that in South Korea, it was also the same thing. So government sometimes would actually encourage companies to form cartels. So it's not a popular, it's not a popular article, but they actually at times where government would actually force companies to get into cartels. And why would they force them to get into cartels? They wanted these companies to be able to get as much profit as they can and also reinvest. But the key thing about all this was that there was competition. That does not mean that competition is not there. So they had systems in place, what I would call what they call reciprocal control mechanism, where there were a system to say, if we give you this advantage to form cartels and whatever, you must in return have 1, 2, 3, 4, 5 things. So I think for me, that is what is very, very important to say. You need to contextualize the situation and also try and also balance the relationship between competition policy and industrial development and trade policies. So thank you very much.
I'm really sorry, but we're going to have to wrap up this afternoon. Thank you to our audience for the great questions and your enthusiastic participation. And Barclay, thanks so much for joining us. I know you had to juggle lots of commitments. And to Tenda and Thomas, thank you for traveling to be with us. It's been a pleasure to see you in person. And Lebo, thanks for keeping it real as always. Great.